Have our teams ready in the ante rooms. All right, let's come on out and we'll get started. I know we're just again. Are you guys? Mayor. Yes. You want to remind me of the live stream so you I will do that. I will do that. Okay. Good morning, Your Honor.
Does it cut into our partners?
No, I'm not going to do that. So that'll just be, that's just part of your time management. That's kind of how I've done reports in the past. It's just ask. Yeah. And we're not going to do like a formal introduction, but I will, once you guys are ready, I'm going to knock on the door and then I'll ask you guys to arrive. And one final we are streaming, so everything here is broadcast.
Good morning and welcome to the 7th District Court of Appeal. We have one case on the docket today. The case is CBA versus State of Florida. Counsel, if you're ready, you may proceed.
Madam Chief Justice, Honorable Justices, and may it please the Court. Good morning. My name is Taeyoung Kim, and along with my co-counsel Charlotte Wu, we have the pleasure of representing the petitioner in this matter. For the purposes of oral argument today, we will be referring to the petitioner as CBA from here on out in light of her status as a minor. Madam Chief Justice, at this time, we would like to reserve 2 minutes for rebuttal.
So noted.
Of the two issues before the Court, I will be addressing issue 1, which is whether the application of Florida Statute Section 836.15 to the petitioner's conduct violated her state and federal constitutional rights to free speech. We are here today to ask this honorable court to reverse the decision of the lower court in denying the petitioner's motion to dismiss for the following 2 reasons. First, Florida Statute Section 836.15 is facially unconstitutional. And second, the application of Section 836.15 to the petitioner's conduct violated her First Amendment rights. Before I proceed with my first reason, I would like to give a brief summary of the facts. After failing to make her high school's basketball team, the petitioner posted a photo of herself on her private Instagram account with a caption calling out the basketball team without identifying the school or any particular players. She left her phone in her backpack and went to gym class, during which time several members of the basketball team saw the post, leading them to walk out of their classrooms and to post on their own social media accounts that they were quitting the basketball team. A parent of a current basketball team member reported the post to the school principal, showing him a partial screenshot of the post and its comments. The school searched the petitioner's backpack and her phone, and CBA was charged with cyberbullying as a result. She filed a motion to dismiss the charge and a motion to suppress the evidence obtained from the search.
Counsel, since we're familiar with the facts, I'm going to jump into a legal question for you. In Tinker, the United States Supreme Court recognized that schools have a special interest in regulating conduct that may be disruptive to the classroom. Do you believe that that is a compelling state interest in this case?
Yes, Justice Ray, we do agree with the court in Tinker that there is certainly a substantial government interest in limiting disruption to the classroom environment. However, considering that this statute is a content-based regulation subject to strict scrutiny, it's petitioner's contention that it is not narrowly tailored to serve that compelling government interest. Turning this court's attention to the analysis by the...
Counsel, if you could wait, I'd like to go back. How would a post about the basketball team's abilities disrupt the classroom environment?
Yes, Chief Justice Rowe, that is precisely the petitioner's contention, that with the Instagram post merely calling out the basketball team, it was unreasonable considering the balancing test set forth by the Pennsylvania Supreme Court in the interest of JJM, considering both the objective contextual circumstances of the post as well as the speaker's subjective intent. It was certainly unreasonable for the petitioner to have created a substantial classroom disruption as a result of her Instagram post.
But is that really true? Let's say that this was actual speech, and during the same period of time that this player who had been cut was saying all of these things in the classrooms or in the hallways of the school. So the time element would be the same. The form of speech would be different. Would that be a different case, or would the same apply?
Well, Justice Alsterhaus, to answer your question, I would like to address once again that there is a balancing test of both objective contextual circumstances and the speaker's subjective intent. So in the case that the petitioner made the exact same statement on school grounds, and she, with the same intent and with the same objective contextual circumstances, it's still petitioner's contention that would still constitute protected speech under the First Amendment, and additionally considering that it would not actually reasonably create a substantial disruption to the classroom environment, it additionally could not fall under the test set forth by the court in Tinker versus Des Moines.
Would your answer be different if the post was about an individual player named, an individual or individuals in the post?
Certainly, Chief Justice Rowe. The fact pattern in the instant case reflects that the petitioner did not make any indication of any particular players at all, or in even the high school that she was referring to when she was speaking about the basketball team. And because of that, it's petitioner's contention that undoubtedly the petitioner was expressing her own opinion about her high school's basketball team, and that is expressive conduct that is protected by the First Amendment. If she had specifically detailed out particular players and made her speech in a way that was, say, violent or more obscene than it had been in the instant case, we would certainly have a different case here today.
But those factors, the physical violence, the intimidation, the threat, are also part of this statute. Are those the safer or more constitutional parts of the statute, so to speak? Or what part of the statute do you have a problem with, given that the statute lays out different
Absolutely,
scenarios?
Justice Osterhaus. To answer your question, I would like to turn the Court's attention to the analysis by the Court in United States v. Williams, which is cited in United States v. Fleury, where they held that if a statute encompasses a substantial portion of protected speech, it is impermissibly overbroad under the First Amendment and therefore facially unconstitutional. So if we take a look at some of the substantial portions regulated by the statute, things like teasing, social exclusion, or humiliation, these are certainly categories of speech that might merely annoy or offend the intended recipients and are certainly protected by the First Amendment. But additionally, even the categories of speech that you laid out, Your Honor, the threat or intimidation, none of these fall squarely within the bounds of the narrowly defined categories of unprotected speech that the courts have defined, such as true threats or fighting words or incitement. Additionally, Your Honors, it's the petitioner's contention that the subsequent posts by the basketball players made by the petitioner by the basketball players in the instant case were not the result of the petitioner's actions, but of others. And it's for these reasons we respectfully ask this honorable court to reverse the decision of the lower court in denying the petitioner's motion to dismiss. Thank you.
Thank you, counsel.
Madam Chief Justice, honorable justices, and may it please the court. Good morning. My name is Charlotte Wu, and along with my co-counsel, Taeyang Kim, we have the pleasure of representing the petitioner in this case, CBA. As my co-counsel has just presented petitioner's argument in regards to issue 1, I will be addressing issue 2, which is whether the warrantless search of petitioner's phone on school property violated her Fourth Amendment rights. We are here today to ask this honorable court to reverse the lower court's denial of the motion to suppress for the following 2 reasons. First, the principal search of CBA's phone did not pass the 2-part reasonableness test established in New Jersey versus TLO. And second, the school resource officer's search of CBA's phone did not meet the consent or exigent circumstances exceptions to the warrant requirement. In protecting people's Fourth Amendment right against unreasonable searches and seizures, government officials are required to obtain a warrant before they conduct a search. However, the petitioner concedes that more than 30 years ago, the U.S. Supreme Court ruled that school officials have the ability to search a student's belongings on school property without a warrant, as long as that search is reasonable. As such, in New Jersey versus TLO, the Supreme Court established a 2-part reasonableness test comprised of 2 requirements. First, that the search was justified at its inception, with reasonable grounds for suspecting that a search would turn up evidence that the student has violated or is violating either the school rules or the law.
So are we going to apply, or should we be applying different tests to the principal versus the school resource officer? I sense the school resource officer is a law enforcement officer. The principal is not, and so do different tests come into play?
Yes, Justice Osterhaus, that is precisely what petitioner's contention here is in the instant case. It is important for this court to understand a clear distinction in the record, as Your Honor pointed out. On page 2 of the record, it clearly reflects that both the principal and the school resource officer searched CBA's phone. And as such, the use of the school resource officer to search CBA's phone implicated additional Fourth Amendment violation, which is why it is petitioner's contention here today that the TLO test no longer applies because of the school resource officer's role in law enforcement. Black letter law establishes reasonableness at the very core of the Fourth Amendment, which is why Lewis versus State held that warrantless searches are presumed to be unreasonable.
Well, certainly, those searches are permissible when certain exigent circumstances exist, like the potential for destruction of evidence. So if you could respond to the argument that there was a fear that these posts would be deleted and that, therefore, there was a need to search the phone and search it immediately.
Yes, Justice Ray. In Kimmel versus California, which is cited by Riley versus California, the court did hold that one such exigent circumstance is the need to prevent the imminent destruction of evidence. However, it is petitioner's contention that there were no exigent circumstances in the instant case. Nowhere in the record does it reflect that there was any indication that petitioner intended to delete her post. In fact, she left her phone in her backpack in the locker room and went to gym class. And she did not have the ability to delete her post.
If I could interrupt on that, I mean, what is her intent? How is that relevant here? I mean, isn't that a little bit retrospective in scope? I mean, if she found out she was going to get in trouble, she may have wanted to delete the post. So don't we need to look at whether the search was reasonable at its inception?
Yes, Justice Ray, most certainly. Firstly, to address the exigent circumstance concern, petitioner's intent is relevant because the record does not reflect that she acted on any intent if she did have that intent. And in answering your question about exigent circumstances, I would like to direct this court's attention to Kentucky versus King, where the courts held that there were exigent circumstances because the police officers heard noises from inside the room that sounded like people and things were being moved inside.
All right, let me stop you there for a minute. Can there ever be an exigent circumstance with regard to a social media post? I mean, aren't those records going to be available from a service provider or even, let's say, Instagram itself?
Chief Justice Rowe, that is precisely petitioner's contention in the instant case. Because the evidence was already preserved, there were no exigent circumstances in the instant case. And further, to answer your question again, Justice Ray, there needed to be articulable facts and circumstances to support the existence of exigency. And in the instant case, there were none. There could be something that could happen or theoretical scenarios which do not rise to the level of exigent circumstances.
Counsel, let me follow up on the point that you made that the evidence was in fact preserved. In what way was it preserved?
Yes, Justice Ray. I would like to direct this court's attention to page 2 of the record, which reflects that a parent of the current member of the basketball team took a partial screenshot of the post, which is why the post was preserved.
But did that reveal any identifying information? Did that post, the screenshot, tie it to the petitioner?
Justice Ray, to answer your question, it is petitioner's contention that the post, although there was no account name preserved in the post, that it was still preserved for the purposes of the school officials, and exigent circumstances did not apply because the post itself was preserved.
Does the fact that it was a partial screenshot tend to support the school in that if there's a partial screenshot of something that looks like cyberbullying, and the reaction of people who are seeing it are to immediately quit the team or leave class and these types of things, could just the investigation part of, hey, what are we dealing with here? I've seen a partial screenshot, but I haven't seen maybe everything, give rise to some sort of investigatory, reasonable reason to search the phone?
No, Justice Osterhaus. Respectfully, petitioner disagrees. Directing this court's attention back to the TLO test, the reason why the search was not justified at its inception was because the only evidence that the school officials had of CBA's alleged cyberbullying was a single partial screenshot without the account name. And as such, it is petitioner's contention that the school officials had no idea whether CBA was the one that did in fact make the post. And because they did not corroborate the screenshot they received prior to searching CBA's post, it is petitioner's contention that the search was not justified at its inception. And further, in the instant case, petitioner also did not consent. In State versus Thomas, the police officers explicitly asked the defendant, would you mind if I search you? In the instant case, the facts and circumstances amount to demonstrative acquiescence to school officials and compulsion by a state actor, nowhere near consent. And therefore, petitioner respectfully asks this honorable court to reverse the lower court's decision denying the motion to suppress. Thank you.
Thank you, counsel.
Good morning, Madam Chief Justice Rowe, honorable justices, and may it please the court. My name is Matthew Rodriguez, and along with my co-counsel, Jake Sang, I have the pleasure of representing the respondent in this matter, the state of Florida. Of the two issues before the court today, I'll be representing issue 1, That is whether the petitioner's state and federal constitutional rights to free speech were violated by the application of the statute in this case, Section 836.15. We'll be asking this court to affirm the lower court's ruling for the following two reasons. First, the statute is facially constitutional. And secondly, the application of the statute to the petitioner's conduct did not violate her First Amendment rights. Beginning with the facial challenge, I'd like to direct the court back to Tinker v. Des Moines. It was the court in Tinker that found that students do not shed their constitutional rights to free speech at the schoolhouse gate. But that same court in Tinker found that conduct by the student that materially disrupts classwork, involves substantial disorder, or involves the invasion of rights of others is not constitutionally immunized by the protection of freedom of speech.
Counsel, I'm sorry, go ahead.
Counsel, so one of the general things that troubles me here, people comment about how terrible sports teams are all the time, and certainly students have an opinion about that. Does every comment, saying that the team is horrible or they shouldn't have lost the game, all of that becomes bullying?
To answer your question, and I think the petitioner brings up a good point here actually, is that the analysis in the interest of JJM that brings up the analysis using subjective and objective considerations in the record is prudent to use here. And to answer your question, it requires a case-by-case basis to determine what is and is not constitutionally protected by the First Amendment. And I'll get into that as-applied analysis later. But for now, with regards to the petitioner's overbroad challenge, it's in the same case that the petitioner brings up for the overbroad challenge, United States v. Flory, in which the court does an analysis and respects the fact that an overbroad challenge is a strong medicine that the courts are hesitant to apply. And the fact is the majority of conduct targeted by the statute is either non-expressive, such as Chief Justice Osterhaus, I believe you bring up, physical violence, or expressive conduct that is not protected by the First Amendment, that are exceptions to the First Amendment's protection as defined by the Supreme Court.
How do we know that that's the bulk of the, I think you said that was the bulk of the cases or the thrust of the statute or something along that line. How do we know? I mean, it seems like using the word teasing, I mean, even in normal close relationships, there's teasing that goes on. How do we know that the thrust of this statute is on the things that are more serious, the physical violence or the threat of harm-oriented conduct?
To answer your question, I believe the thrust of the statute is pointed towards the compelling government interest of preventing disruption within the classroom. And the language in the statute that narrowly tailors it towards that compelling government interest that the petitioner does concede is a compelling government interest focuses the statute on that category of speech that the court in Tinker found is actually not constitutionally immunized by the First Amendment's protection, and is therefore the statute is not targeting protected speech, and therefore the bulk of the statute is targeted towards unprotected speech. That would be language in the statute that narrowly tailors it is language such as the distress having to occur towards one or more students, limiting the target of the statute to affecting students. Language in the statute that requires the communication to take place over technology or other forms of electronic communication, which either imply a departure from school-approved activities or the use of school-approved technology for non-approved school purposes, because the statute requires that the communication inflict physical or psychological distress.
So,
and finally,
counsel, let me just make sure I understand your framework. You do concede that this is a content-based restriction that requires a strict scrutiny analysis. Is that correct?
yes, Justice Wray. Candidly, the respondent would have to agree with the petitioner that this is a content-based statute.
Okay, and I think you said that the compelling state interest here that you concede was to prevent disruption to the classroom. Is that correct?
Correct. The three categories of speech as outlined in Tinker.
Right. Okay. So wouldn't a lesser intrusive means to accomplish that or further the interest of preventing disruption to the classroom be to just simply prevent the use of cell phones in the classroom altogether?
To answer your question, the use of cell phones is not the only way that students disrupt the classroom. For example, and if I could give a hypothetical here, students oftentimes, as the days have caught up to modern technology, are allowed to use computers are allowed to use programs such as Canvas, in which students can communicate with each other on school-approved platforms. And that's why it's necessary for the statute to target broadly all of that electronic communication that inflicts that physical or psychological distress. Because
but
that is,
would the use of Instagram be a vehicle through, I'm not familiar with Canvas. I mean, is that a vehicle that can students can check on their Instagram account during classroom time?
No, Canvas is a platform on which students can communicate and also submit assignments that some schools in this district use. It was just an example to show that schools in the modern day and age are using technology, and some of that technology includes methods by which students can communicate with each other. And therefore, the statute cannot restrict itself towards the use of cell phones because school-approved technology such as laptops can be used for that sort of communication targeted by the statute. And the final piece of language in the statute that narrowly tailors it towards that compelling government interest is the fact that the communication has to inflict physical or psychological distress on another student.
So if a student on the basketball team misses the basket and another student has an opinion, they should have made that basket, we would have won the game. Is that cyberbullying if the person who didn't make the basket feels psychologically distressed?
To answer your question, I believe it goes back to that JJM consideration of both the subjective intent of the speaker in that instance and what is objectively reasonable given the circumstances. And we contend that as applied, this is objectively reasonable, but for your hypothetical, Chief Justice Rowe, we would likely contend that no, that is not reasonable, given it is just a good-natured comment. For the as-applied challenge in and of itself, using the analysis developed in JJM, if we look at the subjective considerations, this was a statement that was very likely made with ill intent. The record reflects that the petitioner had made this post after failing to make her varsity basketball team, and then immediately after having failed to make that team, the petitioner decides to engage in this private humiliation to her group of a wide audience of 523 followers, do this direct insult towards the basketball team, which the record reflects is screw this school, screw this high school.
Is it really all that in common and targeted? I mean, to say that the basketball team sucks, the players suck. Is that the sort of thing that opponents are yelling from the stands? Is that the sort of thing that a coach at halftime might tell his own team?
The distinguishment between that, the hypothetical that you present, Justice Osterhaus, and the instant case is that this communication took place online, in which there's a sense of permanence, as I believe Chief Justice Rowe.
So what if the coach is away from the game because he's got COVID and communicates back to the team at halftime, you guys really sucked it up the first half? Would that and the players take that to heart and are deflated by that? Does that look closer like a criminal violation of the statute?
No, and it would go back to those objective considerations. I believe the difference there being that the coach has an established rapport with the members of the basketball team in that instance, whereas in the instant case, the petitioner having failed to make this team, nothing in the record reflects that she even knew the members of the basketball team.
But we're very early in the case also, right? This is a motion to dismiss, so we don't really know the nature of all the relationships.
Correct, and that's why I think an objective analysis would be required given the facts. And for those reasons, we ask this court to affirm the decision of the lower court. Thank you.
Counsel.
Good morning, Madam Chief Justice, honorable justices, and may it please the court. My name is Jake Sang. Today I have the pleasure of representing the respondent in this case, the state of Florida. Of the two issues before the court today, I'll be addressing the second, on how the trial court's denial of the petitioner's motion to suppress should be upheld based on the exemptions to the Fourth Amendment. We believe that the decision of the trial court in denying this motion to suppress should be affirmed for three reasons. Firstly, because the search conducted by school officials of a student's belongings was in line with the standard established in New Jersey versus TLO. Secondly, that exigent circumstances justify the warrant in the search. And third and finally, because the petitioner consented and voluntarily gave permission to the search being made.
Well, let's start with the exigent circumstances. Are you suggesting there was no other way to discover this Instagram post rather than rifling through this student's backpack?
Your Honor, we believe that specifically for exigent circumstances, the ease of deletion of any online post made it so that there was always going to be concern over the imminent destruction of evidence.
But how does delete, I mean, certainly deleting a social media post doesn't make it disappear forever or from the internet or any other kind of provider, does it?
Your Honor, we generally believe that even that when an Instagram post is deleted, social media companies tend to respect the privacy of their users and not preserve it unless it's explicitly preserved by some other third party. What that would mean is that when that Instagram post was deleted, and if the petitioner were to try to delete that post, then evidence of that post would be lost, and there will only be indirect evidence to try to corroborate the accusations against the petitioner in this case.
Even so, what was the imminent risk of deletion when the petitioner was in gym case, as the record reflects, when this incident was reported? So she didn't even have immediate access to her phone.
Your Honor, for deletion of an online Instagram post, the petitioner need not necessarily have access to the phone on which she posted it. The petitioner could access any other device, such as another computer or simply just another electronic device, log into her account, And with the press of a few buttons, she's able to erase all the evidence that her post was even made in the first place.
Well, was there any evidence in the record below that she was close to a computer? And isn't that the state's burden to put in the record if there was such evidence?
Yes, Your Honor. We believe that because of the ease of access of so many electronic devices in this new age, then there would always be exigent circumstances. Given the fact that it is incredibly easy now in this day and age to access an electronic device, log in on Instagram, and then have many mechanisms through which the evidence can be erased, simply through deleting the post. We would also like to note that in the case of Kentucky v. King, it was ruled that officers need not be entirely accurate or perfectly accurate in their evaluations of whether there were exigent circumstances. Instead, their conduct needs to be reasonable. We believe that in this case, officers had a reasonable expectation to believe that the petitioner could delete the post at any time off her Instagram account.
Did they also have to have a reasonable belief that a crime was being committed?
Yes, Your Honor. Under the TLO analysis that was established in the case New Jersey versus TLO, a two-pronged test was established under which school officers can justify a warrantless search of a student's belongings.
And I think we understand that, but your colleague just talked about this very kind of subjective analysis. We need to know what the poster was posting. So how could the law enforcement officers had a reasonable belief that this wasn't some innocent venting, permissible speech when they searched this backpack?
Your Honor, we believe that the screenshot provided to school officials by a parent of the basketball team, alongside the parent's concern that it could be a violation of the cyberbullying statute, meant that the principal had reason to believe that there was a violation of the law, specifically that cyberbullying statute. We would note that in TLO it was held that school officials, because of their interest in maintaining the learning environment, can conduct warrantless searches of students' belongings under the lesser standard of reasonable suspicion. We believe that the screenshot provided to school officials in this case created that adequate reasonable suspicion for that post being made. In addition, before the principal ordered the school resource officer to seize the backpack and conduct a search of the backpack and phone, he also went to the gymnasium to talk to students about the post and CBA's post being made before conducting that search. We believe that the corroborations and the screenshots sent by the parent, as well as the principal talking to the students, would have established more than enough reasonable suspicion to justify that search being made. In addition, we also believe that the second prong of the TLO test, where it was held that the search must be reasonably linked to the evidence that the officials were attempting to find, was also fulfilled in this case. School officials, after they were sent the screenshot of that Instagram account, knew that they would be finding evidence that the petitioner made that post that implicated her in that crime of cyberbullying through a search of the phone and of that Instagram account. We believe that this is the search that school officials conducted in the incident case, where they searched the phone and the petitioner's Instagram account based on their expectations that they would be finding evidence that the petitioner made this post on the Instagram account. That is the search they conducted in line with their expectations of the evidence that they were attempting to find. Now, going back to exigent circumstances a little bit, again, the exigent circumstances, as held in Kentucky v. King, requires that officers be reasonable in their evaluations of whether exigent circumstances existed. We believe that because these digital sorts of posts can be easily erased both remotely and not necessarily on the phone or on the phone itself, we believe that this created the necessary exigent circumstances for officers to reasonably believe that the petitioner could have deleted the post. In addition, it was held in the trial court specifically that petitioner had the means to delete her post through something like remote deletion, logging in on another account, and using the many mechanisms within these social media websites, such as Instagram, to simply click a few buttons and erase all the evidence that the post was made in the first place. The third and final reason we believe that the decision of the trial court should be upheld is based on the fact that the petitioner voluntarily consented to a search being made. The case State v. Thomas held that the standard to measure the scope of a suspect's consent is objective reasonableness, or what a typical reasonable person would infer based on the exchange between the officer and the suspect. We believe that in the case of State v. Thomas, where it was ruled that the search was reasonable after the defendant in that case never withdrew consent to the search, never objected to the search being made, and never limited the scope of the search, thus justifying the search of the wallet.
But the player wasn't there, correct, when the phone was taken from the backpack?
I'm sorry, Your Honor, can you please repeat that?
I'm trying to find out factually, when did the player give consent to the search?
When told to unlock her phone by the school officials, the petitioner in this case never refused to give consent, never refused to unlock the phone, never withdrew consent during the search, and never limited the scope of her consent during the search. For example, when she saw these officials going to her Instagram account. We believe that as the search was conducted right in front of her, the fact that the petitioner never withdrew consent, never refused consent, or limited the scope of her consent.
Well, are you
meant that-
asking too much of a minor when she is asked by an authority figure? And it wasn't a request. It was, at least as the record indicates, it was amounted to a directive to unlock her phone. I mean, is it reasonable to believe that a minor would have the wherewithal to know that she could object?
Your Honor, we believe that as a 16-year-old, CBA should have had adequate knowledge of her rights to refuse the search. In addition, nothing in the record reflects any coercive circumstances that would have stopped CBA from withdrawing her consent to the search. It's for these reasons that we ask this honorable court to uphold the decision of the trial court. Thank you.
Thank you, counsel.
May it please the Court, I have just two issues that I would like to address in regards to the Respondent's argument. Firstly, on the constitutionality of the statute, the Respondent relies heavily on the analysis by the Court in Tinker v. Des Moines in their analysis. However, a key distinction between Tinker and the instant case that the Respondent failed to articulate is that in Tinker, the punishment was administrative. However, in this case, the punishment would be criminal. The Court in JJM even specifically identified that there is a key distinction between criminal punishment and school punishment for students, highlighting that there must be a higher standard when regards to incurring criminal punishment as a result for speech on campus. And secondly, to respond to the Respondent's concerns about the Fourth Amendment, I would like to address that the Respondent seems to believe that the implication of the cell phone in this case limited the petitioner's rights and made it easier for exigent circumstances or the TLO test to be met. However, we respectfully disagree in that over a decade of precedent has established that a cell phone is a treasure trove of private information and must be diligently upheld to preserve those rights, as the courts have said in Riley and as they've said in State v. KC. It's the petitioner's contention today that upon adopting the Respondent's argument, this Court would be allowing school officials more discretion under the Fourth Amendment than even law enforcement officials. Law enforcement officials, as the case law exists today, cannot search a phone incident to arrest. Law enforcement officials cannot search a phone if it's been abandoned. And in adopting the Respondent's argument today, the Respondent is willing this Court to believe that school officials have such power. And it's for these reasons we respectfully ask this honorable Court to reverse the decision of the lower court. Thank you.
Thank you, counsel. Okay, thank you, counsel. Thank you all. This court will adjourn. Do you want another couple minutes?
I think that we can go as quickly as y'all are able to turn them around, if that's
Sure.
okay with the other judges.
That's
Yeah,
fine.
I know you're on a
sounds good.
tight schedule.
Good morning and welcome to the Supreme Court of Florida. We have one case on the docket today, CBA versus State of Florida. Counsel, if you're ready, you may proceed.
May it please the court. My name is Emily Estes and my co-counsel is Molly Donahue. Today we'll be representing the petitioner, who will be referring to as CBA in regards to them being a minor. I will argue the first issue of whether the application of Section 836.15 of the Florida statutes to the petitioner's conduct violated the petitioner's federal and state constitutional right to the freedom of speech. And my partner will argue whether the warrantless search of the petitioner's phone on school property for access to a private social media account violated the petitioner's federal and state constitutional rights to be free from unreasonable search and seizure. At this time, we'd like to reserve 2 minutes for rebuttal.
So noted. And counsel, if you could speak a little bit louder, please.
Sorry.
Thank you.
All right, so the first issue I take in the trial court's error of this ruling is that the statute is constitutional when it unconstitutionally regulates the freedom of speech. So we do not think that the school had the power to criminalize an act of freedom of speech as they do so with the cyberbullying, making it a criminal offense. Because as the First Amendment states, we have the freedom of speech. And as ruled in Fox v. Hampton's, online speech is just as protected under the First Amendment as spoken word. And here in this case, it was an Instagram post made on a private account where CBA said some not so nice things. And of course, that's just as protected as it would be if she had said it out loud. And we like to bring up the case of Mahonoi, where a student did the exact same thing. They made a social media post insulting the school and some of the students. But it was upheld that they had the freedom of speech to do so because it was...
Counsel, in Mahoney, I recall the facts being a bit different, that the post was made after school hours and off school premises. So can you tell me how you think the facts here are similar in light of those key distinctions?
Absolutely, Your Honor. So we would argue that in Mahonoi, even though they were not acting in loco parentis and it was off school property, not during school hours, we would say that the intent behind the words that both students used would be the same, and therefore we could apply the same principles and circumstance, like under the same circumstance, to say that even though it was on school property during school hours, we cannot criminalize a student for doing so.
Well, didn't in Tinker the United States Supreme Court recognize a special interest in schools, regulating conduct that could have a substantial disruption on the classroom? Do you believe that that is a compelling state interest in this case?
We do not believe that there is a substantial interest. For there to be a substantial interest, it would have to convey a sort of promise of physical or psychological distress would be done on to a specific targeted student, and that was not done in this case.
What if the post had been, player X is the worst player in the state, and we are not going to get to the state tournament because of that player? That doesn't threaten violence directly. Is that bullying under the statute?
The statute limits cyberbullying as online speech, which would be like a true threat. Like that is something that's considered cyberbullying, would be a true threat. And I would argue that saying somebody's bad at something is not a true threat to doing harm or promising harm on their character.
What if it incites other students to violence? Again, we won't make the state championship because of this player.
Sorry, you got me there. I would have to cede to you and say, yeah, that's a little, we would have to. But of course, in this case, she did not say that. She was incited by not making the school basketball team. She was upset. She made a private Instagram post. She did not say, this person is the reason of why I did not make the team. We should do this to that person. It was a private Instagram account. She did not post this all over the internet for the world to see and shame their school. She was merely voicing her opinion on something that happened to her, which we have the freedom to do. And as stated in Tinker, students do not shed their freedom of speech when they enter the schoolhouse. Therefore, she does not meet any sort of circumstance.
So would I be correct in saying that your problem with the statute really goes to the facts of this particular case? Because the statute also does talk in terms of threats, intimidation, physical violence. And so I guess what I'm hearing you say is that part of the statute seems fine, but what happened in this particular case is troublesome.
Yes, as applied, it is unconstitutional. She does not it does not serve a substantial government interest to criminalize this speech. She's not directing violence at anybody individually. She is voicing her opinion, her thoughts, which again, we have the right to do. And she is not, or this, for it to apply to somebody, they would have to warrant the substantial government interest of interfering in this speech and saying, hey, this is not okay. That is not applicable in this case.
Am I correct that you're also making a facial challenge, though, not just as applied to in this particular case, but you think the statute, even if as applied anywhere, is troublesome?
Yes, we are, because it, again, does not, a statute must survive, again, show that it's a substantial government interest to apply to so, and it has to choose the least restrictive means to punish a student for this type of conduct. And as we see in Mahoney and Tinker, those are administrative penalties that they receive, in fact. And in this case, we're dealing with a criminal offense. And I would argue that in Mahoney, her speech is much more vulgar than what my client's CBA had said. And even so, their freedom of speech cannot be violated just on the fact of they were voicing their opinion and it was unpopular. But also, as applied, this statute criminalizes a certain portion of freedom of speech, which is unconstitutional on its face.
Thank you, counsel. Thank you.
Good morning. May it please the court, my name is Molly Donahue, and today I will be arguing the second issue of this case of whether the warrantless search of the petitioner's phone on school property for access to a private social media account violated the petitioner's federal and state constitutional right to be free from unreasonable search and So the trial court erred in failing to grant CBA's motion to suppress data from the recovered phone. The burden is typically on the defendant to prove that the search was invalid, as said in Miles versus State, unless the search was warrantless, as in this case. And both the United States Supreme Court and the Florida Supreme Court have ruled that cell phones are a trove of personal information that exceeds, which is unlike any static object which may be searched incident to a lawful arrest. So in this case, and in Riley, this point is taken further, expressing that the process for police to search a cell phone sees incident to arrest is accordingly simple. You get a warrant. This shows that the burden for the state to have to prove that this search was valid is heightened because of the private information on a cell phone.
Under Riley, can there ever be a legal search of a cell phone?
Yes, there are multiple exigent circumstances that warrant the warrantless search of a cell phone, but we argue that these do not apply. So these exceptions include the imminent destruction of evidence in individual cases, to pursue a fleeing suspect, and to assist persons who are seriously injured or face imminent injury.
And it's alleged here that there is a risk of imminent destruction, and why doesn't that exception apply here?
Well, CBA has over 500 followers on their private social media account. So we would be willing to argue that it is likely that some of those followers would be able to provide evidence to the school officials.
Would it matter if she only had 3 followers?
Well, that would make it less likely since there's less people, but there is still other people having access that could provide the information. So it may change circumstances slightly, but no, because there are other people able to look at the account, that still does not apply. So we also believe that the court erred in their application of the 2-part reasonable test as stated in New Jersey versus TLO. The first part is whether the search was justified on the grounds that the student was engaged in criminal activity or a violation of school rules. We grant that that part is met. There is a threat that this could have been considered bullying under school rules, and that's why it was being looked into. The second part is whether the search was logically linked to what the official was attempting to find. We do not believe that this part was met because the officials already had the evidence. It was already provided by a parent. A screenshot
Well,
was
the
provided.
evidence that they had, and correct me if I'm mistaken, was a partial screenshot without any identifying information as to who posted the Instagram post. Is that correct?
That is correct. It is a partial screenshot, but it does include the first 10 comments. And so school officials would also be able to see who those 10 comments were from and maybe contact them, and without breaking CBA's Fourth Amendment right. So they could be able to contact them and see if they would be willing to provide the necessary evidence before just violating CBA's Fourth Amendment and searching their property. And because both parts are required, and we do accept that the first part is met and the second part is not met, we do not believe that they applied this 2-part rule correctly.
Counsel, may I ask you a question about consent? I believe the state argues or has argued that the petitioner consented to the search of her phone by unlocking the phone and handing it over to school officials. Could you respond to that argument?
Well, because they still had to access and get the phone, first of all. So the fact that they went into their private possessions and got the phone, even though it was unlocked afterwards, showed that they still had the intent to break the Fourth Amendment right and go into their private property.
Okay, thank you, counsel.
And for the aforementioned reasons, we would ask this court to reverse the lower court's decision against the petitioner.
Okay, thank you, counsel.
Good morning, Chief Justice Rowe and honorable justices, and may it please the court. My name is Owen Bader-Schneider, and I, along with my co-counsel, Ms. Rubina Torxada, represent the respondent, the state of Florida, in today's case. I will be discussing the issue of free speech, and Ms. Torxada will be discussing the issue of unreasonable search. On the matter of free speech, we ask this court to uphold the constitutionality of Statute 836.15 as applied for 3 reasons. First, CBA speech is a private matter. Second, the restriction meets the requirements as outlined in the Tinker Standard. And third, the government has a compelling interest in regulating school disruptions such as bullying. This court has held that matters of public concern are at the heart of the First Amendment's protection. In the United States v. Fleury, the Supreme Court ruled that private speech is not a matter of public concern, thus making a restriction easier. Similarly, in CBA's case, her speech does not amount to a matter of public concern. CBA's comments were made on a private Instagram and an individual Instagram. They were never meant for the public. But simply, the restriction
does
of...
that recognize the nature of how social media works, that it sort of goes out from the speaker, and the more interest there is in a subject, if you are challenging, attacking, criticizing the school's basketball team, that's probably going to make its way throughout the community. Can we say that it's really private to the extent that she's broadcasting this into the community?
Justice Osterhaus, we believe that CBA's comments were made on a private Instagram account. Had they been made on a public Instagram account, that would be the case, but she only meant for those messages to go out to to her following.
It seems that the students have less speech than a sportscaster would, who was covering the high school game, who would say, this is the worst team I've seen since 1970. Why should the student not have that same level of speech that someone can make in the public forum?
Justice Rao, we believe that that the newscast is a matter of public concern because they are broadcasting it to the public. CBA was making a private comment which was deemed as hurtful to the basketball team. Put simply, the restriction of CBA speech provides no threat to the free and robust debate of public opinion. Using U.S. v. Fleury as precedent shows that CBA speech is subject to it's lesser protected under the First Amendment.
Well, would you concede, though, that the statute covers content-based expression that's subject to strict scrutiny?
We would concede that, Your Honor. We believe that this statute is a content-based restriction, and we do believe that it meets the requirements for strict scrutiny. This court has long recognized that a content-based restriction is subject to strict scrutiny and must promote a compelling government interest and be narrowly tailored to promote that government interest. We believe that the statute does promote the government interest of limiting classroom disruptions, and that was the intent of the Florida legislature when they passed Statute 836.15. We also believe that it is narrowly tailored because it does list out specific examples that would be applicable under the statute.
Wouldn't a lesser intrusive means to further the compelling interest of preventing disruption in the classroom be just to limit cell phones in the classroom altogether? Cell phone use is prohibited during school.
We believe that that would be a more broad statute, as it would limit any usage of cell phone, even ones that are beneficial to the educational process. The Tinker Standard famously postulated that a student does not shed their rights at the schoolhouse gates. While this principle remains true in this case, there is one caveat to the Tinker Standard. When a student's First Amendment rights can be abridged when they are creating a classroom disruption. CBA's post incited the basketball players to walk out of the classroom, which would have taken away from their learning time, thus creating a material disruption.
Does it matter when CBA makes the post? If she makes the post at home in the privacy of her own home, just opining that the basketball team is horrible, does that matter? I mean, even if it causes a disruption in the classroom the next day?
We do believe that if it does cause a disruption in the classroom the next day, then it would still be applicable under the Tinker standard.
What about if she spoke those words aloud in her driveway and other students were walking by who knew members of the basketball team?
We believe that since those comments would have again been in a more public forum than a private Instagram account, that would not fall under the Tinker standard. Well, the basketball players opened their phone and were upset. They walked out of the classroom. That would have not only created a material disruption for them, but for the other students in the classroom, as it would have garnered their attention seeing the walkout. It would have completely disrupted their classroom experience as well. We believe that CBA's posts created a material disruption across the entire school.
And certainly that, just assuming that is the case, and we accept those facts as true, and Tinker dealt with an administrative penalty, just as Mahoney did, and this is a criminal statute. Shouldn't the state have a higher burden when in criminal statutes as opposed to school discipline issues?
That is correct, Your Honor, but we do believe that they have met that a higher standard, as these comments did incite a mass walkout that would...
Well, they didn't incite violence, as the record reflects, correct? It was some school disruption, but in the grand scheme of things, I think everybody got back to work and there were no threats and no violence. So again, since it's a criminal statute, how did they meet the higher burden?
The state would meet the higher burden, as this also negatively affects the mental and emotional well-being of the students, not only creating a disruption to their learning process, but their life as a whole. For those aforementioned reasons, we ask the state to uphold the opinion of the 7th District Court of Appeals.
Thank you, counsel.
Good afternoon, or good morning, Chief Justice, Honorable Justices. May it please the Court. My name is Rupina Torkzadeh on behalf of the Respondent, the State of Florida, and today I will be addressing the second issue of whether the warrantless search of this petitioner's phone on school property for access to a private social media account violated their federal and state constitutional rights. There are two reasons why we are asking this Court to uphold the decision of the 7th District Court of Appeal. First, the search of the petitioner's cell phone passes the two-part test for reasonableness as established by New Jersey v. TLO. Second, there were exigent circumstances which justify the warrantless search in order to prevent the destruction of evidence as established in Riley v. California. New Jersey v. TLO constructed a two-part test to determine whether the search of a student's property by school officials is a violation of the Fourth Amendment. TLO test determines if the search was justified on the grounds that school officials had reasonable suspicion to believe that CBA was in violation of a school rule or a law. Section 836.15 of the Florida statute states that cyberbullying is bullying through the use of technology or electronic communication. The record states that a parent of the basketball team member at Small Town High School sent to the school's principal a partial screenshot of CBA's defamatory comments, which included a photograph of CBA, their online statements, and the public's response to that comment. In addition, the parent also reported their concerns that CBA's post violated the cyberbullying statute under Section 836.15. Therefore, a reliable source had notified the principal of a possible violation to the statute, and school officials had the grounds to suspect CBA of criminal activity.
They had the grounds at that time, just looking at the screenshot, without having any idea about the intent of the poster.
Yes, Your Honor, as they had the knowledge that CBA's post did incite an effect to the students' classrooms, and they were aware of the public's response indicated by the comments on CBA's post.
Would that have been enough to get a warrant?
Not in this case, no, but under TLO, that is enough to warrant reasonable suspicion, and therefore they were able to search the student's phone.
But didn't the school have other ways to preserve that evidence? I mean, there was a screenshot. There were multiple individuals who could testify that the screenshot, I know it was a personal screenshot, but the screenshot came from her Instagram account. I mean, why was there even a need to access the phone in the first place to get the evidence the state wanted to charge her under this criminal statute?
Yes, Your Honor. Riley v. California establishes that the need to prevent imminent destruction of evidence qualifies as an exigent circumstance. And in this case, the record states that CBA made that social media post through an Instagram account. And therefore, that means if school officials delayed search and seizure of CBA's phone, CBA could have had the opportunity to access the post remotely and alter or destroy incriminating evidence. Therefore, immediate action was necessary to obtain the evidence needed to confirm the criminal statute violation. For example, CBA could have had the ability to alter specific post elements or destroy her account entirely, and therefore any preserved evidence of the post would become useless if CBA had made these changes.
But at the time the incident was reported, she wasn't remotely near her phone, correct? And so, again, I go back to my earlier question, wasn't there other ways to preserve this evidence other than through a search of her phone and her private Instagram account?
School officials at the time were not aware if CBA had been able to access other devices. For example, she could have accessed her account through a friend's phone, any other device that would allow her to log in and change that content.
But at that point, they did know that this had been disseminated into the school community, and so there were multiple points of access to the same evidence.
At that point, they were aware that the public had a reaction to the posts, and they were not aware of CBA's intent with the post, so they cannot say whether CBA was aiming to destroy evidence or not. Therefore, there was an immediate action required to ensure that that evidence was preserved. Any preserved evidence of the post would once again become useless if CBA no longer owned or associated herself with the account. And school officials did have a legitimate need to access CBA's phone to find evidence of the social media post existing on their account.
So they needed it to tie her as the origin of the post, and they couldn't do that by looking at somebody else's phone who had received the post?
Yes, because at that point, CBA could have altered the post or changed her account name, anything to take herself away from the post that was made. For those aforementioned reasons, we ask this court to affirm the decision of the 7th District Court of Appeal.
Thank you, counsel.
All right. May it please the court, two of the most fundamental human rights that we have in America are the freedom of speech and the freedom from unwarranted search and seizure that was laid out by our founding fathers. Here we would argue, as the state had said, that this was a matter of private speech and it was not a matter of a public forum, therefore we can do whatever we want to it. I would argue that that's not so fair. Students, again, don't shed their right to the First Amendment when they walk in the schoolhouse, but CBA's post did in fact go viral. That's what incited the students to walk out, was that the post was being viewed at a humongous scale. And CBA now, she was being punished because of the fact that it was part of a public forum, which is not allowed. She was not being punished because this was a matter of private speech and they could do what they want. They were punishing her because more people had seen this. And yes, the students walking out was a disruption. It was a consequence of what had happened, but she had not incited it. She had not told them to go about and leave their classrooms. And another right that we have, like I previously stated, we have the freedom from unreasonable search and seizure. And CBA's phone, there was no valid reason to seize it. The officials had no warrant, and according to Riley and TLO, the other circumstances do not meet the exigent circumstances or pass the two-part test for reasonableness. It is for those reasons that we ask you to reverse the lower court's decision against the petitioner. Thank you.
Thank you, counsel. Thank you all for your arguments today. This court will stand in recess.
Good morning.
Good morning, and welcome to the Supreme Court of Florida. We have one case on the docket today, CBA versus State of Florida. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. Madam Chief Justice Rowe, Honorable Justices, good morning and may it please the Court. My name is Aditya Sharma, and along with my co-counsel Nitisha Makesh, we have the pleasure of representing the petitioner in this matter, the CBA. In today's proceedings, I will be addressing Issue 1 on whether the application of Florida Statute 83615 to petitioner's conduct violated petitioner's federal and state constitutional right to free speech. For purposes of arguments today, I will be referring to the petitioner as her abbreviated name, CBA, in lieu of her status as a minor. We ask the Court today to reverse the lower court's decision in denying the motion to dismiss for the following two reasons. First, Florida Statute 83615 is facially unconstitutional, as it is both overbroad in its language and fails the strict scrutiny test. And finally, CBA's online statements were protected free speech under the First Amendment. Before I begin with my first point, I would like to begin with a quick summary of the facts. On August 26, the petitioner posted on her private Instagram account, "Screw this high school and this high school's basketball team. The team sucks and everyone on the team sucks." This post went viral and caused the post to be reported to the principal and caused her phone to be seized from her backpack by a school resource officer. After her phone was opened by petitioner, the statements were given to the police in which she was charged in violation of Florida Statute 83615, which states cyberbullying is the bullying through use of technology or electronic communication that inflicts physical or psychological distress on one or more students involving teasing, social exclusions, threat, intimidation, public or private humiliation, or physical violence. The petitioner at trial filed a motion to dismiss and suppress, which were both denied. However, we ask the Honorable Court today to reverse this decision. Firstly, the First Amendment to the Constitution protects the right to free speech and expression. And in order for a law or statute to abridge this fundamental right, it must be not only reasonable, but narrowly tailored to a compelling government interest. And moreover, a statute regulating this free speech has to be either content neutral or content based.
At least on a
Go ahead, Joe.
at least on a facial basis, don't parts of the statute hit at things that government and schools should care about: threats, intimidation, physical violence, speech that carries out those things?
Yes, Your Honor, you're completely correct. And the petitioner will concede in this case that it has been held by this very court that preventing the use of electronic communication to inflict psychological distress on others is an important and compelling government interest. However, the statute presented before the court today does not narrowly tailored to meet that government interest, as it is overbroad in its language.
So, counsel, do you concede then that the statute does cover a compelling state interest, that is, as recognized in Tinker, the protection against substantial disruption of the classroom environment?
Well, no, Your Honor, as there's no language in the statute itself that restricts on or off-campus speech, which is outlined in the ruling of Tinker, and there's nothing in the statute that is for the purpose of preventing substantial disruption. And we can see this in the ruling of Mahanoy versus BL, in which the court ruled that a statute that deals with both legitimate and restricts both legitimate speech and illegitimate speech is an overbroad statute and is unconstitutional. And in the specific wording of the statute, it states the words private humiliation. And this covers a wide range of varying forms of legitimate expression. To put this in perspective, if we look at well-constructed, well-intentioned constructive criticism, this statute would criminalize that by simply it not be taken well by another student and it being posted online.
But here you said that this went viral in the school and sort of caused an uproar in the school. What you're talking about now seems to be much less of a problematic, disruptive-oriented type of situation.
Well, yes, Your Honor. When we look at the language of the statute, it is the objective intent of the listener of who receives the post, and their reaction to the post must be reasonable. And the point, and the major point of why the statute isn't narrowly tailored is the mere fact that this statute criminalizes an overreaction. The mere language of the statute and the mere language of the petition in this case, stating that one sucks, is going to be criminalized under this Florida statute.
What if this was like Tinker and Mahoney, and it was just dealing with school discipline? So it wasn't a criminal statute; it was just a disciplinary measure. Would it pass constitutional muster then?
Well, yes, Your Honor. And even in the event that this court finds that the statute is facially constitutional, when applying petitioner's conduct to the language of this case, her speech is protected as it is political speech. Now, members of the court, this may not be a historical example of political speech. However, in the ruling of Texas v. Johnson, which can be found within the ruling of Flanagan-Enters versus Fulton County, the Supreme Court of the United States redefined in their syllabus the scope of what classifies as political speech as relating to a state, government, or public administration. And furthermore, in the case of Tinker versus Des Moines, they referred to a school as that of a public administration. And therefore, CBA's statements of screw this high school and this high school's basketball team are a direct language relating to that of a school and a school function of that of the basketball team, therefore making her speech political. And the only exception to this political speech was that it incites unlawful and eminent and lawful action. And as has been pointed out by this court, these statements cause members of the court to walk out of their classroom in the middle of the day. However, at no point do CBA's statements incite lawlessness action, therefore making her speech fully protected. And for these reasons, we respectfully ask this court to reverse the lower court's decision in denying the motion to dismiss. Thank you.
Thank you, counsel.
Madam Chief Justice Rowe, Honorable Justices, and may it please the Court. My name is Natisha Makesh, and along with my co-counsel Aditya Sharma, we have the pleasure of representing the petitioner in this matter, CBA. Of the two issues presented before this court, I will be addressing issue 2, which is whether the warrantless search of petitioner's phone on school property violated her Fourth Amendment right to be free from unreasonable search and seizure. This honorable court should reverse the lower court's denial of petitioner's motion to suppress for the following 2 reasons. First, conducting a warrantless search of petitioner's phone violated her Fourth Amendment right and was unconstitutional under the two-pronged reasonable search test set forth in New Jersey versus TLO. And second, school officials did not meet either of the exceptions to the warrant requirement under the Fourth Amendment. Respondent did not obtain a warrant to search petitioner's phone and thus violated her Fourth Amendment right. According to New Jersey versus TLO, school officials do not need to obtain a warrant to search students' possessions as long as the search is considered reasonable. The U.S. Supreme Court establishes a two-pronged reasonable search test to determine the legality of a warrantless search.
Should that principle apply in a criminal case?
Chief Justice Rowe, that principle should not apply to criminal cases because in the Fourth Amendment requires that unreasonable searches and seizures may have to be reasonable, and a probable cause is necessary for a warrant to be established. However, the TLO standard brings this standard of probable cause all the way down to reasonable suspicion in matters of school officials searching students' possessions. Pursuant to Riley versus California, law enforcement may not search a cell phone incident to arrest. Allowing this lowered standard of reasonable suspicion for school officials is giving power to school officials that law enforcement does not have.
Well, what about the exigent circumstances here? At least the state's position is that there was going to be the imminent destruction of the evidence from the phone if the search wasn't conducted immediately. Could you respond to the state's argument on that point?
Chief Justice, or Justice Ray, to respond to your question, Smallwood versus State states that in matters of imminent destruction of evidence, once law enforcement possesses the phone, the imminent destruction of evidence does not apply in the case because the opportunity for Smallwood to delete the evidence on his phone goes away.
But with social media being ubiquitous and accessible from most electronic devices, does the Smallwood reasoning apply here? Couldn't the post be deleted from someone else's phone or from a laptop?
The Smallwood reasoning still does apply, Justice Ray, in that once school officials seized petitioner's phone and brought her out of class, they could have held her and proceeded to wait to obtain a warrant. They had no reason to continue the search without her consent, which was continue an intrusive search. They should have waited to obtain a warrant. Transitioning back to the TLO portion, to address there are 2 prongs in TLO to determine whether a search is considered reasonable, which is as follows. First, whether the search is considered justified at its inception, and second, whether the search is reasonably related in scope to circumstances which justified the interference in the first place. To address the first prong, a search is considered justified at its inception if reasonable suspicion is present. In this instant case, school officials possessed no reasonable suspicion that petitioner engaged in cyberbullying. They were given a partial screenshot, which did not include the account the post was under.
But after this post was made, it went viral, and there was a sort of an uproar. People were leaving classes, and I don't know, running around the campus. I don't know what the extent of it was, but there were real effects here, correct?
Yes, Justice Osterhaus. Although there were effects due to the post, it was completely away from petitioner's conduct. She was in class. She was unaware. She must have been unaware of the destruction of this post, considering the fact that her phone was not on her. It was in her bag in the locker room while she was in class. She was pulled out in the middle of class, given no indication as to why, and school officials brought her phone up to her, who she otherwise thought it was in her bag, and told her to unlock it.
So are you saying that she would not have known that her post would have reached other people and had had an effect?
The record does not reflect that petitioner was aware of this disruption that the post caused, and the fact that the disruption occurred is independent of the post of petitioner, due to the fact is independent of the post of the petitioner. And addressing, in continuing the first art prong, school officials did not see petitioner post this post or even take the photo of herself that was included in the post. Thus, they didn't have proper reasonable suspicion, and thus the search was not considered justified at its inception.
Setting all of that aside, respond to the state's argument that the petitioner consented to the search by unlocking her phone for the school officials.
Justice Ray, in matters of consent, pursuant to Andrews versus State, the burden of proof of determining the legality of this search shifts to the state, as a warrantless search constitutes a prima facie showing. Pursuant to State versus Thomas, this is distinguishable from Thomas in that law enforcement directly asked Thomas if they can search his wallet, which he allowed. Petitioner was never asked. She was told to unlock her phone, a minor being told by the highest authority. It's for these reasons that petitioner respectfully requests this honorable court to reverse the lower court's decision. Thank you.
Thank you, counsel.
May I proceed, Your Honor?
You may.
Chief Justice Rowe, honorable justices, and may it please the court. My name is Lindsay Browner, and today I, along with my co-counsel, Anna Schulman, represent the respondent, the state of Florida. Of the two issues before this court today, I will present the first. How Florida Statute 836-15 does not violate the First Amendment's guarantees for 3 reasons. First, Your Honors, the statute is content neutral. Second, it is able to overcome the 4-pronged test set forth in U.S. v. O'Brien as cited within State v. Conforti. And third, even if this court does find the statute to be content-based, it is still able to overcome strict scrutiny. First, Your Honors, Florida Statute 836.15 is content neutral. If I could turn Your Honor's attention to the case of State v. Conforti, on page 354, you'll find that a statute is content neutral if it is aimed at the non-communicative impact of the act. In this statute, Your Honors, the legislative intent was not to actually limit any sort of speech by saying this speech is allowed under the act, but this speech isn't. Rather, through the act, it is limiting the impact of what these actions can have and limiting the physical or psychological distress that may occur. Seeing that this act is content neutral, it only must overcome the 4-pronged test set forth in U.S. v. O'Brien as cited within this case of State v. Conforti. The first prong, Your Honors, is that it must be within the constitutional power of the government. In this case, being the power of the government to further the pedagogical concerns of schools and make schools a safe place where students are able to go and learn without fear of being bullied. As to the second prong, Your Honor, it must further a substantial governmental interest. As to Justice Ray's previous question, and as the petitioners conceded, there is a compelling governmental interest here. If I could turn Your Honor's attention to page 4, paragraph 5 of the record, you'll find that there is a governmental interest in protecting individuals from online bullying. This is a huge issue that is being seen in schools. Students have been going as
Wrapping back to the content neutrality, so to the extent that they are concerned about bullying, they seem to be concerned about speech that is discouraging, negative, targeted, things like that. Why isn't that a content-based restriction? If you encourage people, if you say nice things about people, it doesn't seem to be wrapped up in the statute, but the other seems to be content-oriented.
Yes, Justice Osterhaus. This specific statute is not saying that these words may not be spoken on their own, but rather we're looking at the impact, and these words cannot be said if it will cause the impact of the physical or psychological distress. That's the part that we're looking at. We're not trying to limit the speech on its face, but rather trying to limit the impact that this negative speech can have on students.
Does that distress need to be objectively reasonable? Something that offends you may not offend me. So how do we, kind of sort that out when we're talking about a criminal penalty?
Yes, Your Honor. As the statute is worded currently, it has two separate sections to it. The first being that there must cause physical or psychological distress, and the second being that it must be through teasing, social exclusion, or a number of other categories listed out in the statute. So because of the nature of these two prongs, it must be first that the person must find that it offends them or makes them have psychological distress, but also objectively, the behavior on itself must fall into one of those categories.
But aren't athletes told that they're terrible or that they suck all the time? I mean, isn't that common?
Yes, Your Honor. And while by a coach or other personnel that's trying to help them, it wouldn't fall under one of these categories as teasing or such. Whereas if someone was making fun of a person or bullying them, then it would objectively fall into one of those categories, which is what in this case would make the behavior criminal. Additionally, Your Honors, and as to prong 3 of U.S. v. O'Brien, the governmental interest must be unrelated to the suppression of free expression.
Counsel, let me ask you a question about a statement you made earlier. I think I heard you say that the state does have a compelling interest or a substantial interest in preventing cyberbullying, correct? What are we to make of the fact that the record indicates that the legislative intent, I assume it's an express legislative intent of this statute, was to prevent classroom disruption? Didn't say anything about cyberbullying. And given that this is a criminal statute, is the legislative intent is that good enough to criminalize conduct?
Yes, Your Honor. While on page 3, paragraph 4 of the record, it does say that behind making these types of statutes, the legislature was trying to eliminate some of the disruptions that go on because of phone use in schools. However, we would allege, and as pursuant to page 4, paragraph 5 of the record, this portion of the statute specifically was more aimed at protecting individuals from online bullying, which can have an impact in the classroom and can cause disruptions in schools. But more specifically to this direct statute, the goal of it was to limit cyberbullying. However, Your Honors, even if you do not find this statute to be content neutral, and rather you do find it to be content-based, it is still able to overcome strict scrutiny. As per page 178 of the case of Miles v. Edgewater, strict scrutiny has two prongs. The first, and as we have laid forth, is that there must be a compelling governmental interest, in this case, to protect individuals from online bullying. And as to the second prong, Your Honors, it must be narrowly tailored. In this case, the only way to actually stop online bullying from occurring constantly in schools and protect these students in an environment where they should be able to learn is to criminalize this behavior, as the legislature has determined it to be necessary. Additionally, this would cause a substantial distraction in classes, as Your Honor was discussing, because as seen in this case and many other circumstances, bullying can cause large disruptions when students become upset and feel like they're not able to learn in a school, which is the main goal.
Counsel, would a less intrusive way to further that compelling state interest be to just ban all cell phones in school? There's no cell phones allowed, or you can't use social media in school?
No, Your Honor. These different apps or phones have different purposes, many being towards safety, allowing one to communicate with one's parents. And as that would make this very dangerous.
Well, what if the rule was you can't use social media in school? You can't use TikTok. You can't use Snapchat. You can't use Instagram. Would that be a less intrusive way to further the interest?
Chief Justice Rowe, I see my time has elapsed. May I briefly answer Justice Ray's question and then conclude?
Yes, you may.
Yes, Your Honor. Banning something sort of social media or other apps like TikTok and Instagram in schools, while that may partially help to solve this problem, those are not the only ways that cyberbullying can be conducted. So in getting rid of part of the issue and still leaving the other part of it there, we're not fully eliminating this cyberbullying issue that's being seen in schools,
and not effectively furthering the governmental interest. So, Your Honors, we would rest on our written brief for the remainder of our argument. For the aforementioned reasons, we ask this court to affirm the findings of the District Court of Appeal for the 7th District and find Florida Statute 836.15 to be constitutional.
Thank you, counsel.
Chief Justice Rowe, honorable justices, may it please the court. My name is Anna Schulman, and today, alongside my co-counsel, Lindsay Browner, we represent the respondent, the state of Florida. Of the two issues presented today, I will present the second issue, that the search of CBA's phone was reasonable and therefore not a violation of her Fourth Amendment rights. The search was not a violation for the following three reasons. First, it was reasonable under the two-prong test established by New Jersey versus TLO. Second, petitioner CBA had given consent to the search. And third, there were exigent circumstances that had necessitated the need to search the phone. The court found that there was a two-prong reasonableness test to determine whether or not a search has violated Fourth Amendment rights, which can be found on page 342 of New Jersey versus TLO. The first prong of this test is whether or not the search had been justified based on the grounds of whether or not the student had been engaged or engaging in criminal activity or in a violation of school grounds. On page 1, paragraph 2 of the record, petitioner CBA had posted a message as well as a picture of herself with the caption, "Screw this high school and the high school's basketball team. All of the players on this team also suck." Now, petitioner's message, which had been handed over by a parent at the school, would fall under this first prong of the test because the school officials were searching for evidence of the criminal activity that they believed to have been occurring from CBA's Instagram post.
This sounds like something that a disappointed person might do when their goal of making the team had been denied, that they might react that way. What part of the statute made this criminal?
Yes, Your Honor. The part of the statute that made this criminal was the fact that it was bullying towards these other students. And as you can see on page 2, paragraph 3 of the record, there was substantial disruption that had been occurring within the classrooms, as there were numerous students who were leaving their classrooms after a result of feeling hurt and depressed as a result of this message that CBA had posted. And because of this, these schools have...
So was it less about the message and more about how people responded to these, to CBA's disappointment?
Well, Justice Osterhaus, it would be both, but in addition, it would be the fact that the school has a goal of maintaining discipline within the school. And this cannot happen if there are students who are walking out of their classes due to a message that has been posted that would be cyberbullying and affecting a large population of the student
Counsel,
body.
going back to a question Chief Justice Rowe asked opposing counsel, was that a reasonable reaction to this post when athletes are criticized all the time, sports teams are criticized all the time? I mean, are we able to look at whether it was objectively reasonable for students to react in the way that they did?
Yes, Your Honor. There would be a difference between a coach versus a student who is giving these messages. Now, with a coach, that would be in a professional setting where they are giving these critiques in order to benefit the players and the students themselves, whereas a student who is disrupting learning environments by saying that people on the team suck is a completely different situation. And further, the second part of New Jersey versus TLO decides whether or not the search had been logically linked to what the school officials were trying to find. And per section 836.15, the school officials were looking for evidence of the crime that had come from petitioner's Instagram account.
And so let's look at where the officials are looking for that. Hasn't the Supreme Court in Riley said that the bar is very, very high before law enforcement can look inside a cell phone to conduct a search?
Your Honor, Riley versus California established on page 402 that a search can be reasonable if there are exigent circumstances that are necessitating the need to search for this Instagram account. That was found here for two reasons. First, there had been an exigent need to prevent a deletion of the account.
Well, at the time the incident was reported, she wasn't even close to her cell phone. So how could there be an imminent risk of the destruction of that evidence?
Justice Ray, I'd like to actually address what you had questioned to Ms. McKesh, was that actually Petitioner could have been accessing this Instagram account from various other methods. She could have been accessing it through a laptop or a school computer. In addition, she could have provided the account to another user who could have then deleted it for her. So whether or not she was in gym class wasn't necessarily the issue. It was an issue that there was an imminent destruction of this evidence that could have happened regardless of whether or not she had the physical phone. Now, further...
But doesn't this swallow the Riley rule? I mean, if the question is, can the cell phone evidence be destroyed remotely, then isn't there always going to be an exigent circumstance in every case involving the search of a cell phone?
Your Honor, while we would concede that that is a possibility, the difference here is that there was an imminent destruction of the evidence, and under TLO, it would have been going to find that logical link between this evidence that has already been provided by a parent from one of the members on the basketball team, and trying to connect that with the evidence of the post from Petitioner's Instagram account.
Couldn't that connection be made? So you just acknowledged that there was a partial screenshot that was provided. We know that it went viral. Couldn't the evidence connecting the screenshot to the petitioner be gathered through witness evidence, witness testimony?
Justice Wright, part of the reason why this search needed to have occurred is because that screenshot did not actually include an account name. So therefore, based on the picture, the officials would have had reasonable suspicion, as petitioners have conceded, in order to go into that phone to ensure that not only did this post come from an account, but that account was actually owned by petitioner on her phone.
But we've been told many times in this court that the internet and the cloud are forever. Couldn't they subpoena Instagram for the information?
Well, Your Honor, we would like to turn the court's attention to New Jersey versus TLO, which established that requiring teachers to get warrants by searching children suspect of criminal law would unduly interfere with the maintenance of such swift and informal disciplinary actions that are supposed to be occurring within schools.
But this isn't a disciplinary action. This is a criminal prosecution.
Yes, Your Honor. However, the goal of the schools and these school officials are to prevent this disruptive action that has been seen going on through schools. And so the immediate action in order to prevent this imminent destruction would be to search the phone. And further, petitioner had given consent by voluntarily typing in her password to give access to the phone. Now, for the aforementioned reasons, we ask that the court affirm the findings of the 7th District Court of Appeal and find that the search was constitutional.
Thank you, counsel.
May it please the court. There are 3 points we'd like to address from hearing respondent's argument. Firstly, Florida Statute 836.15 is not content neutral, as the Florida statute restricts expressive conduct such as teasing and humiliation, precisely because of the psychological distress the content of the speech creates on an individual. As Chief Justice Rowe and Justice Ray have previously questioned, athletes are continuously called out for sucking, and this does not cause this type of disruption, making this disruption in the instant case unreasonable. Secondly, respondent claims schools have a role in maintaining discipline, but in this case, in this prevention of this destruction and maintaining this discipline, school officials are blatantly violating petitioner's Fourth Amendment right in this warrantless search of her cell phone. Students do have a reduced expectation of privacy once they set foot into a school, but they do not relinquish all of their constitutional rights. Secondly, in matters of consent, respondent claims petitioner consented to the search by unlocking her phone. She did not. Under State v. Thomas, Thomas provided general consent in that he allowed the search of his wallet because law enforcement asked him if they could conduct the search. Petitioner was not asked. Petitioner is a 16-year-old girl. She's a minor.
being told by the highest authority at the school, including the principal and a school resource officer, a law enforcement member, to unlock her phone. Thus, it is for these reasons that petitioner respectfully requests this honorable court to reverse the lower court's decision. Thank you.
Thank you, counsel. Thank you all. This court is adjourned.
Thank you.
Good. Okay, then we will really adjourn. I'm going to do my addition real quick. Do that real quick.
Are we breaking now?
Yes.
I'm going to add this real quick before I forget.
Same. You think 10's enough?
10 should be fine, yeah. I didn't do that right.
the 7th DCA or the Supreme Court. We're just like,
Yeah,
sort of just being back.
Every day's an
I had that 7th.
We're sitting as the
Supreme Court, yeah. So the first,
Or something, right?
yep, first time I introduced us as the 7th DCA, and then I realized, you know, we're not, we're justices and all that good stuff. So, yeah, did some orienting. Try to write their names. And I also just adding a layer of context, putting the general times on mine, so just in case.
Yeah.
Something were to in order, that we could put it back in order. Good morning and welcome to the Supreme Court of Florida. We have one case on the docket today, CBA versus the State of Florida. Counsel, if you're ready, you may proceed.
Your Honor, before petitioner begins, we would like to reserve 2 minutes for rebuttal with the court's permission.
Yes, so noted.
Chief Justice Rowe, honorable justices, may it please the court. My name is Pooja Gador, and I, along with my co-counsel, Ryan Lee, represent the petitioner in this case, CBA. Of the 2 issues before the court, I will present the first issue, that the application of Florida Statute 836.15 to petitioner's conduct violated her right to free speech. At this time, petitioner will omit a statement of the facts unless the court would so desire. We ask this court to reverse the decision of the 7th District Court of Appeal for 3 reasons. 1, the statute is a content-based restriction. And 2, given this, it is subject to strict scrutiny, which it does not survive. And 3, the statute was unconstitutional as applied. To begin, the statute is an unconstitutional content-based restriction. While respondent may attempt to argue that the statute is content neutral, because it prohibits speech that constitutes cyberbullying, it is therefore targeting a specific type of speech. The government is making a distinction
between different types of speech based on their content, rather than applying a neutral standard. This directly aligns with the definition of content-based restrictions, as it distinguishes favored speech from disfavored speech on the basis of the ideas expressed, as stated in U.S. v. Flory on page 1364.
But that isn't necessarily a problem, right? I mean, if we're talking about threats and intimidation and physical violence or speech leading to that, then that's permissible, isn't it?
Your Honor, while those categories are not permissible, the statute is content-based because it's looking at those specific categories based on what they're saying and defining that as cyberbullying, and as such, it's categorizing the speech. Now,
But isn't it focused more on the impact rather than the communication itself, whether it's teasing or harassment? What really matters under the statute is if it inflicts physical or psychological distress. So does that make it content neutral?
No, Justice Ray. In this case, the statute is not limiting the effects of cyberbullying, but more so it's limiting what can be said by these students. And given that, it is subject to strict scrutiny, which it does not survive. Under strict scrutiny, the government must show that the regulation promotes a compelling governmental interest, which the statute does not. And has narrowly tailored to achieve that interest, what the statute does not. Per paragraph 3 on page 3 of the record, the interest in this case was to limit the amount of phone disruptions in school. However, the statute was not narrowly tailored as it was overbroad. This statute criminalizes any speech that causes emotional distress to another person, regardless of whether it is actually intended to.
Does that distress need to be objectively reasonable? Is it something that offends you may not offend your colleague? Does it need to be something that would objectively offend anyone?
Chief Justice Rowe, with the way the statute is currently worded, it's not looking at objective intent. It looks at if the student will feel one of the categories. And because of that, if the speaker is not intending to actually cause harm, that is why the statute is overbroad. So for example, if a student journalist goes to a school play and writes a column in the newspaper criticizing the play, and those actors feel socially excluded or feel teased, that student journalist would be criminalized under the statute when they were simply expressing their opinion on the play.
Well, did you concede earlier, though, that the state does have a compelling interest, substantial interest in regulating speech that could materially disrupt the school environment?
Chief Justice Ray, yes, the interest in this case to limit phone disruptions in school is compelling. However, the way the statute is worded does not satisfy that interest.
Well, but if we look at the armbands in Tinker or the Snapchat post in Mahoney, where there was no record evidence of school disruption, I mean, those are different than what we have here. Reasonable or not, we did have students walk out of the classroom because of this. So where the speech was permissible in those latter two cases, why can't it be regulated here?
Justice Ray, in this case, the statute was not constitutional as it was applied because, yes, in Tinker, the actions were permissible, and in the same way in this case, it did not cause a substantial disruption. Now, while Respondent may attempt to argue that this reactions of the student was a substantial disruption, per Tinker, the action must meet the standard of materially and substantially interfering with the operations of the school. However, in this case, a few students walking out of class does not rise to that level of substantial disruption. This disruption was limited in time and scope, as it only occurred on one day, and even in Mahanoy, the disruption was over a few days, and even in that case, it did not satisfy the Tinker standard. For the aforementioned reasons, we ask this court to reverse the decision of the 7th District Court of Appeal and find that the application of Florida Statute 836.15 to petitioner's conduct violated her First Amendment right to free speech.
Thank you, counsel.
Good morning, Chief Justice Rowe, honorable justices, and may it please the court. My name is Brian Lee, and today I will present the second issue, that the warrantless search of petitioner's phone on school grounds violated her right to be free from unreasonable searches and seizures. We ask this court to reverse the finding of the 7th District Court of Appeal for the following reasons. First, there was no reasonable suspicion to seize the phone in the first place. Second, the search of the contents of the phone was overly intrusive without probable cause. And third, the lower court erred in their decision that the search of the phone was the only way to obtain the evidence of the Instagram post. First, there was no reasonable suspicion to search the phone in the first place. We would agree with Respondent that schools are unique settings where there might be reasonable suspicion to search rather than probable cause. However, there still must be reason to suspect that a specific individual committed a specific crime. The parents' report, as well as the students' report, did not specifically identify CBA as the person who made that post, and especially the parents' screenshot that did not have an account name. There's no way to link CBA to the Instagram post itself and to the cyberbullying statute.
But wasn't there a picture involved, and there's somewhat of an uproar going on at school with people leaving classrooms and whatnot? Can't we assume that people know who we're talking about, that the administration knew who they were talking about here?
Your Honor, not necessarily, as there's no reasonable suspicion to link CBA's actual person to the Instagram post. Although it was a picture of CBA herself, it's possible that someone else may have posted that picture, and it's the state's burden today, according to Lewis v. State, which cited Andress v. State, that it's their burden to show the legality of their search, and we contend that they did not have the link between CBA and the Instagram post itself. And second, the search of the contents of the phone was overly intrusive as they did not have probable cause. On paragraph 3 of page 2 of the record, the principal and the school resources then pulled CBA out of class and searched the contents of the phone for access to the Instagram account. In Riley v. California, on page 385, the Supreme Court ruled that phones contain a vast amount of data, and in order to search, there must be probable cause. Just because phones have...
Is that probable cause analysis sort of wrapped up in whether the statute is a good statute or not? I mean, to the extent that you're arguing that it's a bad statute, school officials don't know that yet, and so they are carrying out this broad statute that potentially criminalizes teasing that causes people to be sad.
Yes, Your Honor. The school officials, as well as the school resource officer, was acting under their belief that this law was legal, and they were acting and being held by the Fourth Amendment. And in Riley v. California, the court ruled that just because a phone has so much information, it does not necessarily make it any less subject to the Fourth Amendment protections. And thus, in this case, school officials were still bound by the Fourth Amendment, and they must have had probable cause to search the vast contents of this phone.
But you concede that Riley does allow some searches of cell phones, right?
Yes, Your Honor.
Right. So, and I think that the argument by the state is that there were exigent circumstances here that Riley recognized as an exception. So why weren't the circumstances exigent here?
Yes, Your Honor. We argue that these exigent circumstances did not exist in this case, as there were other methods that officials could have gone to find the evidence of the Instagram post, and thus the second prong, the scope of the search, would not have been met.
What were those other means?
Your Honor, for example, the officials could have asked CBA to log in, say, through a public computer, and this would have linked her to her post. But instead of doing that, they went through her phone. And since my opposing counsel, Mr. Bednar, might argue that schools are unique learning environments, and we would agree with that. And due to that unique setting, school officials can give, say, school detention or in-school suspension after CBA comes out of class, and thus they would have control of both the phone as well as the person, and thus they would be able to have the time to get a warrant.
Counsel,
and finally,
respond to the state's position that Petitioner consented to the search because she voluntarily unlocked her phone.
Yes, Your Honor. The burden is on the state to prove the legality of the consent and the legality of the search, and we contend that they don't have the evidence to prove that this consent was given knowingly, willingly, or voluntarily, as the 16-year-old minor in a school was essentially cornered by two school officials over her, not even asking, but telling her to open her phone, and thus we contend that this does not meet the prongs of consent.
If we disagreed on that point, if we found that she did consent, would your argument still be that the search was still overbroad because of the vast nature of what you can put in a cell phone?
No, Your Honor. If CBA had explicitly consented to the search of the cell phone and said, here you go, I'm giving you my device, feel free to go through it, then we would concede that she did give up consent and officials were justified in their search. However, in this case, CBA did not explicitly say that, and we contend that the state will be unable to prove their burden of showing that consent was willingly, knowingly, and voluntarily given. And finally, the exigence claim that the state, Mr. Bednar might claim, does not exist, as they could have found other ways to go through this with the control of both CBA as well as the phone, and they could have gotten a warrant to search the phone, which would have been way less intrusive. And for the aforementioned reasons, we ask this court to reverse the decision of the 7th District Court of Appeal and find that the search was unconstitutional. Thank you.
Thank you, counsel.
May I proceed?
You may.
Good morning, Chief Justice Rowe, honorable justices, and may it please the court. My name is Danae Warrior, counsel for the respondent, the state of Florida. Today, I will discuss the first issue, that the application of Section 836.15 of the Florida statute did not violate, to petitioner's conduct, did not violate the petitioner's federal or state constitutional rights to free speech. This court should affirm the ruling of the 7th District Court of Appeal for the following 3 reasons. 1, this is a content-neutral restriction of speech and survives the appropriate standard intermediate scrutiny. 2, even if this court finds that it is a content-based restriction of speech, it survives the higher standard of strict judicial scrutiny. And 3, petitioner CBA's conduct was cyberbullying and the statute was applied correctly. Now, regarding the content-neutral restriction of speech, the court in Flanagan Enters v. Fulton County held that if the governmental purpose in enacting the legislation or enacting the regulation is unrelated to the suppression of free speech, then the regulation need only satisfy intermediate scrutiny. If I may direct your Honor's attention to page 3, paragraph 4 of the record, the Florida legislature has determined that the use of cell phones by students during school hours has become disruptive to the classroom environment. As a result, the legislature recently enacted a new criminal statute to punish students for this conduct being the use of cell phones during school hours. Therefore, the current Section 836.15 of the Florida statute constitutes a time, place, or manner restriction of speech.
Okay, so that does prompt a question I have. So if the student here had made the post right after school when she went home and talked about how terrible the basketball team was, and other students had read it, walked out, were incited, all of that, would you concede that there would be no violation of this statute?
Yes, Your Honor. Under the Section 836.15 of the Florida statute, it regulates it during school hours, and using the case precedent from Mahanoy, it suggested that outside of school hours, unless in certain circumstances, this speech would be constitutional. And we can see that this statute upholds that precedent. Now, it qualifies as a time, place, or manner restriction as the prohibited conduct being the use of cell phones by students during school hours, and it's through electronic or technological communication. It does not impose a blanket prohibition on all types of bullying, merely bullying that occurred through the use of technology by students, to students, and during school hours. Now, to satisfy the appropriate standard intermediate scrutiny, the policy must pass what is known as the O'Brien test. On page 984 of Flanagan enters, under O'Brien, an ordinance is valid if, 1, it serves a substantial interest within the power of the government, 2, the ordinance furthers that interest, and 3, the interest served is unrelated to the suppression of free expression, and 4, the restriction of First Amendment freedom of speech is no greater than necessary to further that governmental interest.
Do you concede that this statute is only seeks to stamp out a certain type of speech, which is negative speech, teasing, threats, this kind of thing? It doesn't apply to encouraging speech, to happy statements. It only applies to a certain category of statements that would put others down or put others in physical or psychological distress?
Yes, Your Honor. Under Section 836.15, it only prohibits conduct such as teasing, social exclusion. However,
but is that that's something different than content?
Yes, Your Honor, as it only prohibits this activity during school hours, as stated on page 3, paragraph 4, meaning it is a time restriction, not a restriction on the speech itself, rather when the students can use such speech.
What if the comment appeared on its face to be encouraging? So let's say a basketball player misses the winning shot, doesn't get the free throw, and loses the game, team doesn't go to the state championship, and someone posts a sarcastic comment, they should win the MVP for the state of Florida. Is that going to be, and then it causes hurt feelings and walkouts, is that actionable under the statute?
Your Honor, under the statute, we use an objective listener standard. That standard was from Watts v. U.S., which is cited within the case of the interest of JJM. And they held that Watts' conviction to threatening the president can only be upheld if it conveyed an actual threat. And they ruled that the courts must consider the full extent of the words that were spoken and the totality of the circumstances to determine whether or not it falls under that statute. So that would still apply when the courts and the school resource officers look towards, in your hypothetical, if that constitutes cyberbullying under the statute. And that, once again, goes to what opposing counsel Ms. Gador mentioned regarding her hypothetical about the criticism of the school play. It would still have to go through the objective listener standard that was upheld in Watts v. U.S. and later JJM. Now, regarding the fact that to satisfy intermediate scrutiny for the O'Brien test, for one, the substantial interest was within the power of the government. The substantial interest in this case is to prevent classroom disruptions as opposed to just preventing it only with cell phones. It's the government's interest in this case as a whole to prevent classroom disruptions. And this policy furthers that governmental interest. As while the statute's focus is on the use of cell phones, the prohibition of cyberbullying can be seen as furthering that governmental interest in promoting a safe and productive learning environment by limiting classroom disruptions. And third, the interest does not aim to suppress free expression by students, rather restricts students from expressing their free speech that constitutes teasing, social exclusion, etc., during school hours and through technology. For the current restriction of First Amendment rights is no greater than necessary to further the government's interest, as it does not prohibit all cyberbullying, as mentioned earlier, merely cyberbullying during school hours. Now, if the court finds that it is a content-based restriction, our point still stands, as the compelling governmental interest is to prevent classroom disruptions and produce a safe and productive learning environment. Thus, that would, and in the case of Fox, they held that the use of internet that inflict emotional distress on others serves that compelling governmental interest. Therefore, that stands, and narrowly tailoring, it's expressed in no uncertain terms. Lastly, CBA's conduct was cyberbullying. The team sucks and all of the players on the team sucks qualifies as teasing, and it was through technology or electronic communications. We rest on our brief for the remainder of the argument, and we ask that the court uphold the lower court's decision and find the statute to be constitutional. Thank you.
Thank you, counsel.
Good morning, Chief Justice Rowe, honorable justices, and may it please the court. My name is Daniel Bednar, counsel for the respondent, the state of Florida, and today I will argue the second issue, that the warrantless search of petitioner's phone on school property does not violate her constitutional rights to be free from unreasonable search and seizure. This court should affirm the ruling of the 7th District Court of Appeal for the following 3 reasons. 1, the warrantless search was reasonable under the 2-part standard established under New Jersey versus TLO. 2, the search was subject to exigencies that required immediate action without a search warrant. And 3, the petitioner voluntarily consented to the search of her cell phone. Your Honors, on page 326 of New Jersey v. TLO, the court concluded that the legality of a student's search should depend simply on the reasonableness under all the circumstances of the search.
Now, how reasonable was it here when what they were going to get on her phone would be I would guess the very same or similar thing that they would get from the recipient's phones? And I guess you had multiple people walking out of classrooms all who had seen this post. A parent had notified the school of the post, so it seems like they had the very same evidence that they were going to get by looking at the phone.
No, Your Honor. There was a need to gather additional evidence in order to verify the initial information that they received from the parental report. We concede that the parental report and the screenshot did not specifically include an account name for the post. And furthermore, it was necessary for school officials to continue to build and establish that specific link between the petitioner herself and the post in question.
Well, why couldn't the state get a warrant for that? This is a criminal statute, not a school disciplinary regulation.
Yes, Your Honor. School officials were unable to obtain a warrant as there were certain exigent circumstances, namely the imminent risk of a deletion of evidence through deletion of the post or the account, that would have prevented them from obtaining a warrant in today's case.
And how is that imminent risk present when the student wasn't even near her phone at the time the incident was reported and the phone was discovered?
Yes, Your Honor. If I could turn Your Honor's attention to page 2 of the record, it indicates that the petitioner was in the gym and the phone, which was inside the backpack, was within the girls' locker room, presumably a short distance away between the girls' locker room and the gym. Furthermore, the petitioner would have had the ability to delete the post or the account in question after the petitioner was called out of class to go to the principal's office. The petitioner also saw the substantial disruption that was caused by the post in question, and also saw that many basketball team members were upset, which may have motivated the petitioner to delete the post in question.
What does Riley tell us about warrantless searches of cell phones?
Yes, Your Honor. Well, we concede that Riley does hold that cell phones are a treasure trove of personal information, unlike certain static objects. Riley does allow an exception to the probable cause and warrant requirement, specifically in the case of exigent circumstances.
Thank you. So let's drill down on that a little further. The assertion here is we're afraid CBA is going to delete the information. Isn't that true in almost every cell phone case, that we're afraid the defendant is going to delete the information that converts every passcode or every cell phone case into a exigent circumstances case? The exception swallows the rule, doesn't it?
No, Your Honor. In Riley, it simply required that the police officers have a reasonable belief that the petitioner in today's case would delete the post. Considering the substantial effects that I just mentioned and the fact that she was called out of class, this may have specifically motivated the petitioner to imminently delete the post in order to avoid the repercussions that would come from facing consequences for that post.
But even so, as Judge Osterhaus has mentioned, that post went viral. So there were probably hundreds of witnesses that could connect the screenshot that was provided to school officials with the petitioner. So why was it necessary to search the phone to obtain that evidence when it seemed it could have been redundant to evidence the state could already obtain?
Yes, Your Honor. There were no other lesser intrusive means of obtaining the necessary evidence, because going through, as the petitioner would contend, going through the 523 other followers of this private Instagram account could not specifically establish that the petitioner had actual connection and control over the account in
What
question.
about for the viewers that saw it, the basketball team members that were so upset about it? Could they not make that connection?
No, Your Honor. The only way to make that specific connection would be to ask the petitioner to go into her Instagram account. Once she went into her specific Instagram account and school officials saw that the post in question was contained on petitioner's actual account, then that would be able to establish that she did have control over the account in question. That would be the only way to reasonably establish that link.
But it still doesn't tell us whether CBA was the author of the post, right? It could have been a dad, a mom, somebody else who had access to the phone.
Your Honor, going specifically into the petitioner's phone to find the Instagram account would more directly establish the link that the petitioner was the one in control, as opposed to various other parties, as you have suggested. As Justice Ray mentioned, going through other Instagram followers who were affected by this post would not be able to establish this link, as there would be the possibility that another person would have had access or control over the account, and we would not know whether that would be the case going by that standard. It is more reasonable to go through the petitioner's post and her account and her phone herself. Lastly, the search was valid as the petitioner consented to the search. The record indicates that the petitioner was told to unlock her phone, and by voluntarily typing in the password into the phone, that was a grant of consent to school officials.
Can a minor give meaningful consent when the principal and a law enforcement officer are hovering over her, asking her for her password?
Yes, Your Honor. The courts have repeatedly found that actual knowledge of the right to refuse consent is not a necessary element of a consent search. It is reasonable to believe that despite the existence of the school principal or the resource officer there, the petitioner would still be able to say no or say yes to the search. In this case, the record indicates that she did not expressly give disapproval. Rather, she specifically typed in her password, granting consent to these school officials.
But she wasn't asked whether before they proceeded, she wasn't asked whether she would give consent.
Your Honor, recognizing that my time has elapsed, may I briefly answer your question and then conclude?
May.
Yes, Your Honor. Although the record does specifically say that she was told to unlock the account, by the mere fact that she did input the password upon that request, that would indicate consent to search. And furthermore, there was no withdrawal of consent later on. For the remainder of our arguments, we rest on the brief on the merits. And for the aforementioned reasons, we ask that this court affirm the ruling of the 7th District Court of Appeal and find that the warrantless search was constitutional.
Thank you, counsel. You may proceed.
May it please the court. In 1969, Justice Fortas wrote, "Students do not shed their constitutional rights to free speech at the schoolhouse gate." However, that is exactly what happened to my client in this case. Addressing the first issue, Mr. Warrior contends that the statute regulates content during school hours. However, the statute does not state that anywhere, and that is exactly why it is overbroad. Further, Mr. Warrior relies on the objective standard. However, per Elonis v. U.S. on page 78 of the JJM case, the higher court concluded that a conviction which is premised solely on how his post could be understood by others could not stand, because such a standard is unconventional with the requirement for criminal conduct being intent. Addressing the second issue, in regards to Justice Ray's question for Mr. Bednar about other alternatives, while Mr. Bednar contends that there is an exigency of the destruction of evidence, there are other alternatives which would have sufficed. For example, asking CBA to log on to her personal Instagram account on a public computer, or giving CBA school disciplinary measures, and in that way, the school could have gotten a warrant in that time, or even if it came down to it, officials could have subpoenaed the company of Instagram, because even if CBA were to delete the post on her end, she would always leave that digital footprint, and the post would be accessible somewhere. For the aforementioned reasons, we ask this court to reverse the decision of the 7th District Court of Appeal and find that the application of Florida Statute 836.15 to CBA did violate her First Amendment right to free speech, and the search of her phone was unconstitutional. Thank you.
Thank you, counsel. Thank you all. This court is adjourned. Good afternoon. Welcome to the Supreme Court of Florida. We have one case on the docket today, CBA versus State of Florida. Counsel, when you're ready, you may proceed.
Should I speak into the mic or?
Yes.
All right. May it please the court, your honors, and opposing counsel. My name is Alexander Santiago Jess, and alongside my co-counsel, Gabriel Garcia, we represent the respondent, CBA, or the petitioner, CBA, against the respondent, the state of Florida. This case is about bullying, the bullying of CBA by the government, which took place on August of 2021. Around this date, CBA got news that she did not make her basketball team. After hearing this, she took to Instagram and made a private post to her private account of 523 followers. This post said, "Screw this high school and this high school's basketball team. The team sucks and the players on the team also suck." After a series of events, CBA was charged with violating statute 836.15. This statute is a cyberbullying statute that reads, "Cyberbullying is bullying through the use of technology or electronic communication which inflicts physical or psychological distress upon one or more students. This involves teasing, social exclusion, threats, intimidation, public or private humiliation, or physical damage."
Do you dispute that there was public or private humiliation on the part of the basketball players who were shamed?
Yes, Your Honor. I will delve into that in my as-applied challenge. There are two questions in this case. One, was the application of the cyberbullying statute a violation of CBA's freedom of speech rights? And 2, was the warrantless search and seizure of CBA's phone a violation of her Fourth Amendment rights? I will handle the First Amendment issue, whilst my co-counsel Gabriel will handle the Fourth Amendment issue. But to answer the question, yes, the application of the cyberbullying statute was a violation of CBA's freedom of speech rights. This is because the statute was wrongly applied in this case, and because the statute itself is unconstitutional.
Do you agree that under Tinker, the state has a compelling governmental interest in regulating conduct that could substantially disrupt the school environment?
Yes, Your Honor, but in this case, we believe that this was not the intent of CBA. Therefore, it does not apply.
Well, and so to what extent do we look at her intent as opposed to how the receivers of the information digested it? I mean, we certainly have evidence in the record that several students walked out of class, so there was a disruption to that effect, which makes this case different than Tinker, the armbands in Tinker, and different than the Snapchat post in Mahoney, correct?
Yes, Your Honor. But it is different at the same time because these students were not specifically in humiliation by this post, but instead in agreement. They were walking out of class because they agreed with CBA and they resonated with her message. I will raise an as-applied challenge as well as a facial challenge. To go over to my as-applied challenge, the post itself did not violate the 836.15 statute. This is because 4 elements need to be met for the statute to be violated. Those are the use of technology or electronic communication, which inflicts physical or psychological damage upon one or more students, and it involves the aforementioned criteria. We could see that CBA did use technology, but the other 3 elements were not met, as CBA did not intend or humiliate anyone, and on top of that, she did not bully anyone. Therefore, the following elements were not met. In addition to that, we mentioned the Mahoney case, and in the Mahoney versus BL decision, 3 speeches can be regulated by the school. These speeches are lewd speeches that are uttered in a class assembly, speeches that pertain illegal drug usage that are uttered on a class trip, or speeches that involve the imprimatur of the school, such as them being posted in a school newspaper or in a school blog post. Again, none of these speeches fall in line to what CBA said and what she posted.
Let me try to misunderstand you. Are you saying that's the only, those 3 categories are the only type of speech schools have the authority to regulate?
As outlined in the Mahoney versus BL decision, this would be the case.
Didn't Mahoney go on to recognize that Tinker held that schools can regulate conduct that have a substantial disruption effect on the school environment?
That is also true, Your Honor, in the case of Tinker.
Okay, thank you.
But additionally, as you mentioned in the Tinker case, students do not shed their freedom of speech rights as they walk past the schoolhouse gate. So the difference in the Mahoney versus the difference in the case that we are discussing today is that one was not in school while the other was. But regardless, as Tinker mentioned, schools should not be able to regulate students' speech just because they pass through the schoolhouse gate. Additionally, there's a facial challenge that I raise. This facial challenge is that the law itself is unconstitutional because it is a content-based law that does not pass judicial strict scrutiny. There's 2 different types of speech regulating bodies. These are content-neutral laws and content-based laws. Content-neutral laws regulate time, place, and manner, whilst content-based laws regulate the expression and ideas contained within the message being expressed. This law in particular is a content-based statute, and it does not pass the standard for it to be constitutional, which is judicial strict scrutiny. Judicial strict scrutiny, in this standard, the state must prove one of 3 things: that the message being expressed is of clear and present danger, or that it constitutes a defamatory falsehood, or that this court is able to rule an exception under which it can...
But does the statute address those kind of things? I mean, it talks in terms of threats, of intimidation, of physical violence.
Your Honor, the statute does argue about that, but at the same time, the state is not able to prove that the message in particular in this case, CBA's case, is not of clear and present danger, as CBA is not inciting anyone to commit any type of violence or crime. Instead, she's just expressing herself and offering the subjectiveness of her statement.
Yeah, I was thinking more in terms of your facial part. I get the as applied that this isn't a case of physical violence, of intimidation, of threat, but on the facial side, to the extent that this statute does hit things where government would have a compelling interest, that's where I was wondering where the problem was.
But in that case, Your Honor, at the same time, there's less restrictive means to regulate the speech. The school could have offered a suspension, or they could have offered some sort of administrative punishment, whereas instead she was charged with violating a criminal statute, which in this case we concede that it is not constitutional. Your Honors, was the application of the cyberbullying statute in violation of the freedom of speech rights of CBA? Yes. As you've heard in my as-applied challenge as well as my facial challenges, CBA's rights were violated. At this moment, I'd like to reserve any remaining time after my co-counsel for rebuttal, and thank you for your time. My co-counsel will argue the Fourth Amendment issue.
So noted. Thank you, counsel.
May it please the Court, Your Honors. My name is Gabriel Garcia, and I will be addressing the second issue of this case, the Fourth Amendment. Was the warrantless search and seizure of CBA's belongings a violation of a Fourth Amendment right? Yes, Your Honors. Yes, we believe it was a violation of her Fourth Amendment rights. My co-counsel stated that there was a series of events that happened that day. I will account these series of events. First, the principal gets shown a post by a parent of one of the students in the basketball team. After seeing this post, he decides to do something and goes down to CBA's class and tries to find CBA's belongings. After getting a word-of-mouth tip from a student that they heard buzzing in a backpack, the principal then got a research officer and was able to search the bag and find CBA's phone.
Is the thrust of your Fourth Amendment argument the seizure of the phone from the bag, or is it what happened after that?
Your Honor, my argument is about the unreasonable suspicion, unreasonable search, and unreasonable consent. The other events that had happened that day were that after the search of the phone, CBA was brought down to unlock her phone, and after the phone was unlocked, they sent it to the police to say that CBA was violating 836.15. After that, CBA filed for a suppression of evidence, but it was denied. My 3 points are, as you've heard, unreasonableness of suspicion, unreasonableness of the search, and unreasonableness of consent that happened.
Could you address what Riley says about the search of a cell phone?
Riley states that a warrantless search is okay if the need to prevent the destruction of evidence is around.
And isn't that exactly what the state is arguing here? They were very concerned that your client was going to delete the evidence. So why aren't exigent circumstances present in this case?
Yes, Your Honor. This is what they're trying to argue. However, this is not the case in this scenario because of the hashtag basketball sucks. Now, hashtag is where people post like-minded content on a topic and repost posts about the topic. This hashtag was about CBA's post and had thousands of reposts on it of CBA's post. Therefore, the principal could have gotten it from the hashtag. The principal could have gotten it, could have signed in on a school device and gotten the post from CBA's account, could have gotten the credentials from CBA's account and signed in on a school device.
Wasn't the concern, though, that she would delete? There was an imminent risk that she would delete the post, and if, based on the record, or at least the trial court found that would be amount to the destruction of evidence.
Yes, Your Honor. However, there is also caches and savings of Instagram posts that they could have gotten from the Instagram itself, even with a warrant, if they got a warrant. However, like we know, they did not get a warrant.
With that in mind, could there ever be exigent circumstances to search a phone for a social media post? I mean, if Instagram or Facebook always retain this information, could a law enforcement officer ever show reasonableness for an exigent search exception?
Reasonableness, Your Honor, reasonableness for an exigent search on a social media account shouldn't be necessary, but on a phone, yes, because you can permanently delete stuff off of a phone. So it's the it's like where it is posted on a phone, on a device.
Well, I always tell my son everything's permanent when you post it on social media. And to a certain extent, I think that's true. And maybe this supports your position. Couldn't the state have gotten the information, the evidence from subpoenaing the records of Instagram?
Yes, Your Honor, that is exactly my point, that there were other methods of attaining this information.
Well, let me ask you about the state's position argument that your client consented to the search by voluntarily unlocking her phone for school officials.
Well, Your Honor, as I'm going to state in my third point, this was not consent, Your Honor. This was a following of a command. CBA, a teenage girl, is called down by two authority figures and told to unlock her phone. Now, a teenager questioned or commanded by two authority figures believes that they don't have a right to object. They don't have the right to deny the command, or else they are afraid of the unknown consequences of what would happen if they don't. As well, she felt intimidated, and she felt like she couldn't have a choice of consent. So it was just following a command. Thank you, Your Honors. This is why we believe her Fourth Amendment right was violated, and that the decision to deny evidence should be reversed. Thank you, Your Honors.
Thank you, counsel.
May I proceed, Your Honor?
You may.
Chief Justice Rowe, honorable justices, and may it please the court. My name is Sophia Masnikoff, and along with my co-counsel, Olivia Robbins, today we represent the respondent in this case, the state of Florida. Of the two issues before this court, I will address the first issue, that the application of Florida statute section 836.15 did not violate petitioner's constitutional rights to free speech. There are three reasons this court should affirm the judgment of the 7th District Court of Appeal. First, Florida statute section 836.15 does not survive strict scrutiny. Second, petitioner's actions fulfilled all elements of the statute. And finally, the application of the statute did not violate the First Amendment protections of free speech.
Since you're arguing a strict scrutiny analysis, do you concede that this is a content-based regulation?
Yes, Justice Wray, absolutely. This statute is a content-based speech restriction, and based on the decision and based on the court in Miles v. City of Edgewater Police Department, the court stated that content-based speech restrictions will not survive strict scrutiny unless the government can show that the regulation promotes a compelling government interest and that it chooses the least restrictive means to do so. In this case today, the government interest of protecting individuals from online bullying was compelling because students should be free from psychological distress in schools.
Well, let's talk about psychological distress. Is there an objectively reasonable standard here? Because what might offend you may not offend your co-counsel.
Yes, Your Honor. A student can use their reasonable person standard to see what psychological distress would be caused to them, and in this case, it is the legislature decided that regulating cyberbullying was a prominent issue, and therefore, because of the psychological distress that can cause self-harm in students and many other psychological issues in students, and therefore that's a prominent issue that they needed to regulate in this case.
And certainly, I understand the legislative intent there, but is it reasonable for an athletic team to have psychological harm when someone says they're terrible? I mean, don't people say that all the time about sports teams? when they lose?
Yes, Your Honor. However, in this case, when students say that about other students, it causes psychological distress, and they're not just talking about the sports teams, they're inflicting harm on the students themselves. And
But the facts of this case were more of a broad sweep type statement,
Yes, Your
correct?
Honor.
That the school sucks or what have you, the team sucks. It wasn't personal to any particular.
Yes, Your Honor. However, they still felt public humiliation in this case because the post was shown to CBA's followers, which included their peers at their high school and also members of other basketball teams that they compete against in their county. And
So doesn't a team face public humiliation when they lose?
Yes, Your Honor. However, this CBA's actions of posting this go further than that and propose psychological distress and public humiliation on these students that is unnecessary and is not constitutional. Further, the statute is narrowly tailored to achieve that interest of protecting individuals from cyberbullying because the language in the statute is clearly focused on protecting students from bullying and psychological distress through the means of technology, which in this case CBA used technology such as Instagram to conduct her cyberbullying. Further, the application of the statute did not violate the First Amendment protections of free speech. In Tinker v. Des Moines, the court established a need to balance students' First Amendment rights with their goals and needs of educators in the community.
Counsel, I wanted to ask you about whether the Tinker analysis is really appropriate here. I mean, to your opposing counsel's point, this is a criminal statute. So shouldn't we consider more traditional First Amendment principles rather than kind of the reasonableness test that's developed in Tinker for use for school rules, discipline, suspension, things of that nature?
Yes, Your Honor, but Tinker applies in this case because the students' First Amendment rights were being limited by the school, and Tinker upheld that they do not shed their school rights their rights to free speech in the schools. However, they allowed the schools the right to prescribe and control conduct in schools when there's an interference in school activity, which we see in this case both in their attendance in classes and on the basketball team with games and practices.
Counsel, you addressed in your opening that the least restrictive means, test applies here. So was it the least restrictive means here to go through a criminal prosecution versus, say, suspending the student or doing something different to address the conduct?
Yes, Your Honor, because the legislature does not have the power to suspend students in schools. That would be an administrative power, so the legislative power that they used was the least restrictive means. Further, the school's purpose is to educate, and it should be and CBA's post directly disrupted the school's goal in educating students by affecting their attendance in classes, and multiple students were walking out of their classes because of the post. And further, in Mahanoy Area School District VBL, the court held that a school could not regulate a student's social media post that was made off campus. However, in this case today, CBA's post was made on campus and during one of her school classes, and therefore the school has the right to act in loco parentis to regulate her speech because of the disruption that it was causing within the school. So therefore, they were correct in applying that statute and did not violate her rights. So for the aforementioned reasons, this court should affirm the judgment of the lower court and find that Florida statute section 836.15 is constitutional and did not violate petitioner's rights to free speech. Thank you.
Thank you, counsel.
May I proceed?
You may.
Chief Justice Rowe, honorable justices, and may it please the court. My name is Olivia Robbins, and along with my co-counsel, Sophia Masnikoff, together we represent the respondent, the state of Florida. Of the two issues presented, I will address the second issue. The search of CBA's phone was constitutional in accordance with the Fourth Amendment. Your Honors, there are 3 reasons why this search was constitutional. 1, reasonable suspicion applies here pursuant to New Jersey v. TLO. 2, even if probable cause is found to be the correct standard, exigent circumstances overcame the warrant requirement. And 3, CBA gave consent to search. Now, Your Honors, in New Jersey v. TLO, it set forth that reasonable suspicion is the standard for searches in schools. These prongs for the 2-part test were that 1, the search must be justified on the grounds that the student was engaged in criminal activity or school rules, and 2, the search must be logically linked to what the officials were attempting to find.
Do we have to parse this out a little differently because there's both a principal and I presume a law enforcement officer or a school safety officer was there? Are there different standards that apply there that come into play?
No, Your Honor. The standard for the officer must be pursuant to New Jersey v. TLO because they're acting within the actions of a police officer. So even though the principal isn't acting within those same responsibilities of a police officer, they still have to follow the reasonable suspicion standard because they're acting within schools. And so this standard set forth is met in this case by the informant that connected CBA's bag to CBA.
Now, does the record show that the informant actually connected her to the post? So we have a partial screenshot where a parent obviously wasn't able to connect the petitioner, and then we have the basketball player that said, well, there's a cell phone in that backpack, but what connection was made, if any, between the petitioner's backpack and her making the post?
Yes, Justice Ray. So that connection between the post and the bag is made through 2 different links. So that link between CBA and the post itself was made by the report from the parent about the cyberbullying. And so that featured a picture of CBA. And so even though that didn't include account names that we could be absolutely certain, it is enough for probable cause to constitute that suspicion that a crime may be afoot within CBA. And then that further connection between CBA and the bag itself was made by the informant. And so that reasonable suspicion for searching the bag was met in this case. And then the search was logically linked because there was a partial screenshot in the post that didn't confirm the identity of the post maker, which was necessary. And so going to the source of the information on CBA's phone was the most reasonable way to confirm the identity and find the most reliable evidence in a world of technology.
Was that the most reasonable way? I mean, I think Riley tells us that searches of cell phone you have a pretty high bar because there's a lot of information there. You're arguing that the circumstances were exigent. There was no other reasonable way to get this information?
So, Chief Justice Rowe, while we recognize that phones have a higher burden outside of schools, within the school they do not, pursuant to New Jersey v. TLO, where that standard is reasonable suspicion. And these exigent circumstances arise from the fact that the evidence could have been deleted remotely anywhere. And so opposing counsel, Mr. Garcia, brings up Instagram records. However, that would not establish the clear enough link that was necessary to connect CBA to the post that was made. So those Instagram records could identify the account that made the post, but that wouldn't have clearly identified CBA as the maker of those statements.
Well, even getting her phone, we wouldn't know that, correct? I mean, it could have been a parent who had access to her phone who posted that, or a friend who posted that. So it's not even determinative of the authorship, is it?
While we acknowledge that there will always be uncertainty within social media and technology, there is a clearer link by going directly to the phone to establish that the specific account that the post was made on belonged to CBA. And so that would establish a clearer link as opposed to what could be accessed in those Instagram records. There were also further exigent circumstances to mitigate the negative effects that occurred because of the post that was made. So even though the post was made, these students were upset and they were feeling the effects of what was made. And so there was a need to delete that information to mitigate those effects.
But couldn't those students connect the dots and preserve the evidence that the state needs to to prosecute this crime? In other words, you have the screenshot and you have a viral video which multiple members of the basketball team saw and reacted to. Couldn't they have connected the dots and obviated the need for the search of someone's personal cell phone?
No, Justice Ray, that wouldn't be a reliable enough link between the post, the account, and CBA and her phone itself. And so going onto that phone was enough to establish a clear enough link that wouldn't have been able to have been made by accessing the evidence on a different means. Now, CBA also gave consent in this case. So CBA overcame that reasonable expectation of privacy when she took the action of putting in her password on the phone. And so while we recognize that the school resource officer and the principal didn't explicitly say that she didn't have to comply, we would direct your attention to Kentucky v. King citing INS v. Delgado, where they cite, while most citizens will respond to a police request, the fact that people do so, and do so without being told they are free not to respond, hardly eliminates the consensual nature of the response.
Was the defendant in that case a minor, and was this in the school context?
No, Your Honor. These are distinguishable facts. However, it's still reasonable that CBA could have made objection or asked why she needed to open her phone. And so it is reasonable to assume that she could at least ask for the purpose of opening her phone. And so putting in that password number was enough to constitute the consent that was required to search that phone. So, Your Honors, for the remainder of our argument, we rest on our written brief, and for the aforementioned reasons, we ask that this court affirm the decision of the 7th District Court of Appeal and find that the search of CBA's phone was constitutional in accordance with the Fourth Amendment. Thank you.
Thank you, counsel.
Before I begin, may I ask how much time I have for rebuttal? Yes, please. Thank you. May it please the court, your honors, and opposing counsel. CBA's freedom of speech rights and her Fourth Amendment rights were violated. Her freedom of speech rights were violated. As the school may have regulated the speech, there were means to restrict the speech that were less restrictive. This could have been, as Judge Ray has mentioned, these could have been means such as suspension, or they could have even taken away the phone. In my circumstance, my school takes away my phone and has my parent come in. So they didn't even have to search the bag itself or seize the phone and go through it. What the school could have done is the school could have seized CBA's phone, put it away, and eventually had someone unlock it with an actual warrant. Your honors, in addition to her freedom of speech rights being violated, her Fourth Amendment rights were also violated. This is because there were no exigent circumstances in this case that would have allowed for a warrantless search to take place. These exigent circumstances may have been the case if the evidence could have been destroyed, but as you've heard from my co-counsel, this is not possible with the new advances in technology, specifically in social media. This is because posts are almost permanently on the internet. Via screenshots or other logins or caches, posts rarely are able to be 100% deleted. And even if there needed to be a direct connection between the post and account, this could have been done, again, if the phone was simply just locked out, and CBA, with more reasoning and with a better circumstance, she could have unlocked her phone with consent. As there was no consent in this case because CBA felt threatened by the police officer and the principal, which are arguably the two most important bodies of authority in a school. For these reasons, her rights were violated. Thank you.
Thank you, counsel. Thank you all. This court is adjourned.
Oh, is that one? I think 105. She wanted
105 is
to keep
perfectly
this on.
fine. Yeah, absolutely. Thank you.
Yes, thank you. Would you mind asking David to shut us down for an hour? Oh, I'm sorry, actually, he actually mentioned that for Chris. I'll call Chris. Oh, okay. I know you have special access, which is the only reason I asked you.
So we'll reconvene a little bit before 1 o'clock.
Perfect.
Very good. I'm going to retire